may we request MP Sheikh Ibrahim Ali to lead us in the invocation, to be followed by the singing of the Philippine National Anthem and the Bangsamoro hymn.
Bismillahirrahmanirrahim. Amin ya rabbal alamin. Alhamdulillah rabbil alamin. Ar-Rahmanir Rahim. Maliki yaumiddin. Iyyaka na'budu wa iyyaka nasta'in. Ihdinas siratal mustaqim. Siratal ladzina an'amta 'alaihim ghairil maghdubi 'alaihim waladdallin. Amin. Allahumma waffiqna lima tuhibbu wa tarda. Allahumma balligh murana ya Allah. Allahumma la taj'al dunya akbar hammina wa la mablagha ilmina ya Rahman. Allahumma rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzaban nar. Sallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi wasallam bi rahmatika ya arhamar rahimin. Walhamdulillahi rabbil alamin.
Mga kababayan, ang pambansang awit ng Pilipinas. Kayang magiliw, helas ng sinakanan, alam ng puso, sa dikit mo'y buhay. Lupang hinirang, tuya ka ng magiting, sa manlulupin, di ka pasisigil, sa nagagang tutok sa simoy at sa langit mo bangaw, ay hinagang tulad, awit sa pagkayang minamahal. Ang isang ng matawad mo'y tagumpay na nag-iindig, ang bituin at araw niya kailan pang ay di magdidinig. Luman ang araw ng walang pagsingka, buhay langit sa piling mo. Ang inigaya ng partay mga amin, ang mamatay ng dahil sa'yo.
Simula noon hanggang ngayon, isa ang naging layon. Magkaisa ang magulong, kagitingan ay marugtong. Tumayo tayo mula sa hamon ng nakaraan, niyabos ang panganib na umaanlang. Pinangako sa puso at paniniwala, ang ginhawa para sa kabataan. Bangsamoro ay tagumpay, bunga ng pawis, sugo at buhay. Kapayapaan, katarungan, ay atin ang nakamtan. Alhamdulillah, alhamdulillah, pagpalain Bangsamoro. Bangsamoro, Bangsamoro, lagi kang mamahalin. Walang pipigil sa damdamin, mga pangako'y tutuparin. Habang buhay kami sa'yo'y magbabantay, mananatili sa puso't isipan. Ang kahapong ngunit ay nanagbuwis ng buhay, nasa piling na ng may kapal. Bangsamoro ay tagumpay, bunga ng pawis, sugo at buhay. Kapayapaan, katarungan, ay atin ang nakamtan. Alhamdulillah, alhamdulillah, pagpalain Bangsamoro.
The Secretariat, please check the attendance of the members of the BTA Parliament to determine the existence of quorum for the conduct of today's business.
Roll call of the honorable members of the BTA Parliament: Abbas Ahmad, Abbas Harun, Abbas Basit, Abu Mujib, Katia Laisa, Alauden Mosber, Ali Ibrahim, Ali Lanang Jr., Ali Edi, Ambuludo Suharto, Aminuddin Abdulaziz, Ampatuan Baintan, Anayatin Susana, Antaw Muhammad Kelly, Arnado Merian, Asnawi Idan, Babaw Ali Muntaha, Balindong Pangalian, Basman Adna Tarhata, Pandaw Bay Maleha,
Present.
Dilanggalan Hasimi, Dumama Alba Shia Ilayha, Ibrahim Ahud, Ismail Suharto, Estino Matarol, Gayak Abdullah, Gera Edward, Haji Abdullah Khalid, Hasim Abdullah, Hasan Hatimil, Iqbal Muhagger, Ismail Rasul, Jajuri Raisa, Jakilan Muslimin, Chikiri Al-Bakil, Kahalan Den Martin, Karon Faisal, Lim John Anthony, Long Benjamin, Long Don Mustafa,
Present.
Lorena Jose, Makapar Abdullah, Makasalong Marjani, Makatanong Amrosi, Maglangit Tarhata, Malik Hamid, Mantawil Baileng, Mastura Eshak, Matalam Japar Apollo Mikael, Mawalil Amil Bahar, Mendoza Proilin, Mitimbang Michael, Mitimbang Tawakal, Miswari Abdul Karim, Miswari Norreda, Mitmo Grasol Jr., Munoz Hussein, Uranon Sueb, Pakasam Obaida, Pak Abdul Wahab, Pangandaman Nabila Margarita, Parcasio Randolph, Piang Ramon Sr., Ramos Jamila, Salindab Said, Salik Ali, Sangki Ali, Sema Omar Yasser, Sema Romeo, Ek Said, Silongan Aida,
Present.
Ding Kadil Jr., Sulaiman Ali, Tago Faisalin, Tan Nabil,
Present.
Pan Adsfar, Uto Basir, Uy Oyod Siti Fahani, Yaqub Muhammad. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Mr. Speaker, on the basis of the roll call and with 39 members of the Parliament physically responded to the call and 8 responded via Zoom, we have a total of 47 members of the Parliament present in this today's session. Mr. Speaker, we certify the presence of quorum.
With 47 members of the Parliament present physically and virtually, with the certification of the Secretary General and the existence of a quorum, we will proceed with today's session.
Bismillahirrahmanirrahim. Assalamualaikum.
Recording in progress.
Assalamualaikum to the Honorable Speaker, Attorney Pangalian Balindong, Presiding Officer, Deputy Speaker, Attorney Omar Yasser Sema, Deputy Speakers who are present, members of the Parliament, staff, secretariat, and guests. Magandang umaga po. Mr. Speaker, I move that we dispense with the reading of Journal number 17 of the August 15, 2023 session, Mr. Speaker.
There is a motion from the floor that we dispense with the reading of the journal number 17 of August 15, 2023. It's been seconded. I'm hearing no objection. The motion is approved.
I move that we approve Journal number 17, Mr. Speaker, subject to style.
With the further motion from the floor that we approve the same journal, subject to style, it's been seconded. The motion is approved.
Thank you, Mr. Speaker. We now move to the main agenda in the order of business, which is committee report number 40, submitted by the Committee on Local Government on BTA Parliament Bill number 30, entitled An Act Providing for the Bangsamoro Local Governance Code, authored by the government of the day. Mr. Speaker, I move that we allow the committee Chair, Attorney Raisa Jajuri, to present the committee report.
There's a motion to proceed with the presentation of the committee report number 30.
40.
40 rather, 40. It's been seconded. Hearing no objection, the motion is approved. The chair of the Committee on Local Government is recognized.
Thank you, Mr. Speaker. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Mr. Speaker, distinguished colleagues, as chair of the Committee on Local Government, I have the honor of presenting to the plenary committee report number 40 to cover BTA Bill number 30, or the Bangsamoro Local Governance Code. As we all know, this is a priority legislation as provided in the Bangsamoro Organic Law. So today, dear colleagues, ladies and gentlemen, the government of the day and the Committee on Local Government are both happy to start the plenary process through which this bill may be enacted into law. BTA Bill number 30 has undergone careful scrutiny, especially from the time that it was referred to the Committee on Local Government. Aside from position papers received from all around the region, there were 8 public consultations in all the Bangsamoro provinces, Cotabato City, and the special geographic area, and a consultation with experts and stakeholders outside and within and outside the Bangsamoro. Thereafter, a series of meetings to deliberate on the provisions was conducted to discuss each section of the bill, from Book 1, Section 1 to Book 4, Section 554, and introduce amendments thereon. A small group was constituted composed of some of the floor leaders to facilitate the discussion and decision-making on the proposed amendments. Alhamdulillah, after 23 years of deliberations, sometimes during weekends, the committee concluded its proceedings and hereby submits its report for consideration of the plenary. Allow me to highlight the contents of the bill. Number 1, empowerment of local government units. The proposed measure enumerates in detail the powers to be devolved to the different levels of local governments, giving clarity to the delineation of responsibilities between and among them, thereby ensuring that the constituents know what services and facilities are forthcoming and or can be demanded from their barangay, municipality or city, or the province. With the provisions on devolution, the Bangsamoro local governments will be at par with all the other local governments in the country in terms of providing relevant services to their constituents. We all know that these other local government units outside of BARM have been providing these services since more than 30 years ago. At the same time, the ministries and offices in the BARM will have to reorganize and restructure themselves in order to provide services to the same constituents at a regional level, supplementing the services of the local governments. Note that Bill number 30 does not show us the mandates and services of the regional ministries. We will have to look at the Bangsamoro Autonomy Act 13 or the Bangsamoro Administrative Code for that. Note further that with the enactment of the Bangsamoro Local Governance Code, Bangsamoro Autonomy Act 13 is amended insofar as ministries will now have to share or devolve some of their powers and responsibilities to the local governments. Number 2, gradual devolution. Note that there shall be a gradual devolution to ensure that the transfer of power is carefully done and that there is technical and financial capacity on the appropriate level of local government. And just to make sure that all the services of the government are made available, there is still the power of the higher local government unit or the Bangsamoro government to augment in case there is still a lack of said capacity. Mandatory and optional positions are listed for each level of local government correlated to the powers that are to be devolved. Hence, there may be plantilla positions that are under the ministries now that may then have to be transferred to the local governments as the primary responsibilities are devolved to them. Number 3, provision of equitable share in the revenues collected. While the taxing powers of the local government units are reiterated, the bill also provides for the sharing schemes between the Bangsamoro government and the local government units in the region. On 1, collection of national taxes in the Bangsamoro region. And number 2, collection from the revenues from the exploration, development, and utilization of natural resources in the region. These additional resources, together with the collection from taxes, fees, and charges that are within the powers of the local government units, shall add to the financial capacity of the local governments to execute their mandates and provide the services and facilities expected of them in view of the devolution. Number 4, democratization and empowerment of local communities, including vulnerable sectors. The constituents of the local governments are assured that they have the power of initiative, referendum, and recall. In addition, vulnerable sectors such as women, workers, and other sectors are assured of sectoral seats in the Sanggunians, which shall be subject to elections and shall not be reserved to relatives of powers that be. Indigenous peoples are also given seats in the barangay, municipality, city, and province, so long as they % of the population and are not occupying more than 50% of the seats in the Sanggunian. A provision similar to that found in the Bangsamoro Electoral Code will also democratize the choices in the candidates from those who do not come from the same families. Although we have provided for a transition period to make sure that our leaders and our voters are ready for this. And number 5, supervision, cooperation, and coordination between the Bangsamoro government and the local government units. This code is replete with guidance as to how the local government units relate with the Bangsamoro government, being constituent units thereof. This covers the sharing in the revenues, as I mentioned before, appointing powers in case of vacancies in local government units, exercise of disciplinary powers, representation in regional structures and specific bodies that have or will be established, and the devolution framework mentioned earlier, among others. These, my dear colleagues, are part of the innovations that we have included in the Bangsamoro Local Governance Code Bill. We look forward to our continued engagement as we shape the governance in the BARM to that which is responsive, efficient, participative, and will work within the framework of moral governance as espoused by our Chief Minister, Ahod Balawag Ibrahim. My colleagues, let me just thank everyone who has given time and effort in scrutinizing Bill number 30 by attending the committee processes from the public hearings, submission of position papers, participating in the deliberations and amendment of the bill, leading to these plenary processes. We also thank the Secretariat for working extra hard during these times in order for us to reach this stage in enacting the Bangsamoro Local Governance Code. Wassalamualaikum warahmatullahi ta'ala wabarakatuh. Thank you, Mr. Speaker.
Alaikum salam, Floor Leader.
Thank you, Mr. Speaker. May I ask for 5 minutes suspension, Mr. Speaker?
Before we break, can you move that we adopt the committee report for deliberation?
Okay, I move that we adopt the committee report number 40 of the Committee on Local Government for deliberation.
There's a motion from the floor. It has been seconded. I'm hearing no objection. The motion is approved. The committee report is hereby adopted for deliberation. Session suspended for 5 minutes. Floor Leader?
Yes, Mr. Speaker, we are now we have just adopted the committee report number 40, and I now move to open the period of interpellations and debate.
Yeah, before I act on the motion, may I ask whether copies have already been distributed? Committee report, whether hard copy or soft copy of this the committee report?
Yes, Mr. Speaker. Yes, last night, after the session was adjourned yesterday, a copy, soft copy, e-copy, a 600-page, more than 600 pages matrix have been distributed to members of the Parliament via email, Mr. Speaker. As of the moment, the Secretariat are distributing hard copies of both Books 1 and 2, Mr. Speaker.
Right now, our process is we should agree on those who are ready to interpolate. We will give you the floor. Already, those who seem are not ready because probably the copies have arrived to your offices very late. We will give you time to prepare. Anyway, we have allotted a certain number of days for the deliberation of this very important piece of legislation. We will give you time. Also, the chair will guarantee that everyone who has questions will be given time to ask their questions, whether on a specific matter or on a matter of general principle governing this very important document. So there is now a motion from the floor to open the period of interpellation debate. Any second? Yeah, before that, those who are in the Zoom, if you think that your audio or your signal is not sufficient to sustain you to ask questions, because probably the audio of your mechanisms or your laptops, your computers are not good, we will give you the opportunity to submit your written questions to the chair of the committee so that he can answer it thoroughly and with clarity. No. Also, may I invoke from you colleagues that if your questions has already been asked, I think it would be better not to repeat the question unless you want an elaboration of the answer that was given to the previous question asked ahead. So, I think that would give order to what we are doing and to so that we can fully expedite and hasten the process. So it has been seconded. I'm hearing no objection. The motion is approved.
Mr. Speaker, first in the order of interpellation is Member of the Parliament, Amil Bahar Mawalil. May we recognize MP Mawalil.
The gentleman from Tawi-Tawi is recognized.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuhu. First of all, I'd like to thank the presiding officer for the generous gesture of allowing us, I think, unlimited time to ask our questions. And first, I would ask some general questions about the Bangsamoro Local Government Code, and I will proceed to the specific questions. Mostly are found in the Book 1 of the draft code. Will the good proponent yield to some of my questions, Mr. Speaker?
Mr. Speaker, yes, we're willing to answer questions.
Mr. Speaker, why is there a need to enact our own Bangsamoro Local Government Code?
Mr. Speaker, I think most of us, I think all of us know that this piece of legislation is one of those that are mentioned in the Bangsamoro Organic Law. So the first answer would be because it is in our mandate as the Bangsamoro Transition Authority, meaning within the time frame of the transition, we should have enacted this law. Second, and I guess that would be the real reason, is that we are a government. We are a regional government. We have constituent units, and it should be very clear in the relationship between the Bangsamoro government and the local government, what principles apply, what powers are with the regional government in relation to the Bangsamoro local government units, and also the powers of the local government units. Such would be found in a local government code in the Bangsamoro, Mr. Speaker.
Thank you for that response, Mr. Speaker. Mr. Speaker, we all know that the last priority code that we passed encountered some challenges in the higher court. Local government code, as far as the proponent is concerned. Are you confident, Mr. Speaker, that the provisions under the Bangsamoro Local Government Code are constitutional?
Mr. Speaker, I will not venture to make a guess as to whether there will be petitions raised in the Supreme Court questioning the constitutionality of the local governance code. But in the for the committee, we made sure that we also looked at the constitutional limitations, and that what we pass now as the local governance code in the barn would pass the test of constitutionality. But we cannot predict, nor can we stop anyone from going to the Supreme Court, Mr. Speaker.
Thank you, Mr. Speaker. Now, my next question, Mr. Speaker, is that the proponent earlier delivered her sponsorship speech, and she highlighted, I think, 5 points that are basically integrated in the draft code. The first on the list, Mr. Speaker, she said, is that the draft code contain provisions that intends to empower local government code. For this point, Mr. Speaker, can we, in general, cite some provisions, or how did you integrate this point, Mr. Speaker?
Mr. Speaker, on that first item in the highlights, one would have to look at specifically Book 3, which provides for the powers of local government units. So we tried, Mr. Speaker, to list down the powers, responsibilities, the services, the facilities that are supposed to be within the mandate of each level of local government. So there would be a list for the barangay, another list for municipalities, for cities and provinces. So this way, Mr. Speaker, we are clear as to the powers that can be exercised by these LGUs, Mr. Speaker.
Thank you, Mr. Speaker, for that response. For the number 2 question, you've cited gradual devolution. This also pertains to the local government units. How did you integrate this devolution in general, considering that we also have the Mandanas-Garcia ruling and among other existing regulations and laws?
So, Mr. Speaker, after enumerating the powers, the next question would be, how do we transfer these powers that are still with the regional government, with the ministries and offices in the region, to the LGUs? So in the, I think in Book 2 and also in Book 3, you will find that there is a period of time within which we expect the transfer to be fully to be completed. So we say that within 5 years, the devolution should have been completed. 5 years from the enactment of the code. There is also a devolution committee that is proposed under Book 3. And this devolution committee will first make an assessment as to the capacity of the LGUs and then make a timeline considering the capacities or the lack thereof so that we can reach the full devolution. So there's going to be a plan for the LGUs to complete the devolution from the region to the LGU.
Thank you very much for that response, Mr. Speaker. Mr. Speaker, among the highlights that the proponent cited earlier include the provision of equitable share in the revenues collected. So how do you think were integrated in the draft code, Mr. Speaker? And what is the relation of this particular provision in our intent to legislate our own internal revenue code?
Mr. Speaker, since this is a provision, this sharing scheme stems from a provision in the Bangsamoro Organic Law, which also states that the local government unit should have a share to the revenues of the regional government, of the Bangsamoro government, in relation to the exploration, development, and utilization of natural resources. We deemed it fit to include that in the local governance code. So there's a provision, particularly in Book 2, pertaining to this. So there's a formula where we say that all LGUs in the BARM shall get an equal share of revenues received from the exploration, development, and utilization of natural resources. But a certain portion of the revenues would also be distributed in accordance with the locus of the natural resource, which is the subject of the revenue. So a portion would be equal share and a portion would be distributed based on the locus of the natural resource. As to the share in the collection of national taxes, that's also provided, I think also in the Bangsamoro Organic Law, no? And therefore, we deem it also fit that we mention that here. This is also to ensure that local government units know that aside from the national tax allotment, their own revenues coming from local enterprise development, they also have shares in collections coming from the national government. From the Bangsamoro government.
Thank you, Mr. Speaker, for that response. Second to the last highlights that were cited by the proponent is the democratization and empowerment of local communities, especially vulnerable sectors. We mentioned the relationship of the indigenous people's group and the settlers, the women's. How was this integrated in the draft code? And can we cite a particular provision, maybe?
Okay. As I mentioned in the speech, we retained provisions pertaining to the power of constituents, of residents to recall local officials, to undertake initiative and referendum as well. But in addition, while we retain the sectoral representation provision, which is found also in the national laws, we made sure that the 3 sectoral representatives would be elected and that they are independent. I think except for the representative coming from indigenous peoples where
They will choose.
the election
Yeah.
can be based on their cultural practices. But we are presenting a formula for the identification of the third sector. So under the law, the first sector would be women. The second would be workers, whether agricultural or industrial. And the third sector is left to the discretion of the sanggunian. But in this case, considering the composition of the population in the BARM, we're proposing that the third sector be automatically given to indigenous peoples if they constitute 10% of the population or more, or less, or more. And the elected officials would not be more than 50% of not more than 50% would come from the indigenous people, meaning they are a substantial number, but they are still a minority, but they do not have political power in the local government. So this time we're giving that seat to this minority group so that they can participate in legislation and other political processes. Mr. Speaker.
Thank you, Mr. Speaker, for that answer. And last highlight that the proponent cited earlier is the supervision, cooperation, coordination between the Bangsamoro government and the local government units. But I would like to read the succeeding sentence. And quote, the code is replete with guidance as to how the local government units relate with the Bangsamoro government, being constituent units thereof. Mr. Speaker, can we elaborate on this? What do you think is what do you think are the
Main highlights.
specific provisions? Maybe one provision that sets this draft code from the National Local Government Code.
Okay, Mr. Speaker, I think one of the more important provision
Yes.
would be that which provides for the regulation of the affairs of local government units. This is the term used in the Bangsamoro Organic Law. And we've ventured to explain what regulating the affairs of local government units mean, and how it relates to supervising local government units. And this pertains to the Bangsamoro government, supervising the LGUs. So we put some details on what regulating the affairs of local government units mean. This is found in section 28. And as I said, there are so many provisions in the bill, also pertaining to the supervision of higher LGUs over lower LGUs, and how the chief minister or the MILG exercise certain powers over local government units, Mr. Speaker.
Thank you, Mr. Speaker, and that ends my questions for the general questions, Let me proceed to my specific ones under Book 1, Mr. Speaker. So my number one question, Mr. Speaker, for the specifics. Under Section 3, Operative Principles of Decentralization, local officials and employees whose salaries are fully charged against the local funds shall, unless otherwise provided under this code, be appointed by the governor, mayor, or punong barangay, or the vice governor or vice mayor, as the case may be, according to merit and fitness, and may only be removed for cause subject to the civil service law, rules, and regulations in the Bangsamoro Civil Service Code that may be enacted by the Parliament. For this part, I think some, if not most of the provisions are copied from the national LGC. My only question is why not adopt the provisions from the National Local Government Code, Mr. Speaker?
Well, Mr. Speaker, yes, actually we, as a working draft or as a main reference, the law on local government, local governments of the national was used as the frame for this law. But for paragraph C, section 3, this is not exactly the same because as we all know, we passed the Bangsamoro Civil Service Code. And definitely that is not in RA 7160. But the general idea is that LGUs shall leaders, officials will appoint the other employees of their local government and based on merit and fitness, and can only be removed for cause based on law. I think this is a general principle which we also want to adopt in our own law, Mr. Speaker.
Thank you for that answer, Mr. Speaker. My next question, Mr. Speaker, is section 3. Still under the operative principles of decentralization. Letter E, Bangsamoro Autonomous Region in Muslim Mindanao with respect to provinces, component cities, independent component cities, highly urbanized cities, municipalities and cities and municipalities with respect to component barangays shall ensure that the acts of their component units are within the scope of their prescribed powers and functions. Correspondingly, the Ministry of the Interior and Local Government shall ensure faithful compliance by the constituent local government units with their obligation through the proper use of their prescribed powers and accomplishment of their functions. Mr. Speaker, I have some comments here, but I would like to direct my questions. Why is there a need to add the last sentence despite the very clear provision prior to it? That the bar with respect to provinces, component cities, municipalities, and cities ensures that the acts of their component units are within the scope of their prescribed powers and function.
Yes, Mr. Speaker, if you will scrutinize this paragraph, the first one talks about the power of the Bangsamoro government having supervision over provinces, component cities, independent component cities, and highly urbanized cities. Okay, that's one really set of relationships. And then the other one is of municipalities and cities with respect to component barangays. That's the second. And then we're also saying that considering the mandate of the Ministry of the Interior and Local Government, we also want to make sure that local government units are able to exercise their functions in accordance with the powers and responsibilities, especially in the light of the newly devolved powers. As we all know, the Ministry of the Interior and Local Government also has municipal local government operations officers who work in relation or together with the local government units to which they are assigned. These local government operations officers are present in all municipalities and in all provincial governments. And the idea is for MILG to support the work of local governments and ensure that they are able to exercise their powers as provided by law.
Thank you, Mr. Speaker. Last on that note, Mr. Speaker, why are the words component and constituent exchanged frequently in the proposed draft?
Yes. With respect to component, Mr. Speaker, I think this is used usually in relation to component cities. So component cities are those that are part of a province. They vote for officials of the province. And they are not independent of the province compared to what we call independent component cities, which may be geographically within a province but are not part of the province. No? The constituent units, when we speak of constituents, they are part of the higher LGU. So when we say constituent barangays, it may be the constituent barangays of the higher LGU, which is a municipality or a city. And so therefore, the component city is the component municipality or city is a constituent unit of the province. Magulo?
Thank you, Mr. Speaker, for that explanation. Mr. Speaker, may I proceed to my next question? Under Section 18, power to generate and apply resources. And I will read the provision. Constituent local government units shall have the power and authority to establish an organization that shall be responsible for the efficient and effective implementation of their development plans, programs, objectives, and priorities, to create their own sources of revenue and to levy taxes, fees, and charges which shall accrue exclusively for their use and disposition and which shall be retained by them, to have a just share in national taxes which shall be automatically and directly released to them without need of any further action, to have an equitable share in the proceeds from the utilization and development of the national wealth and resources within their respective territorial jurisdictions, including sharing their respective territorial jurisdiction, including sharing the same with inhabitants by way of direct benefits, to acquire, develop, lease, encumber, alienate, or otherwise dispose of real or personal property held by them in their proprietary capacity, and to apply their resources and assets for productive, developmental, or welfare purposes in the exercise of furtherance of their governmental or proprietary powers and functions, and thereby ensure their development to self-reliant communities and active participants in the attainment of national goals. Mr. Speaker, from its conception, are there allocations to constituent LGUs from the block grant? If yes, how much in percentage?
I think, Mr. Speaker, for the block grant, there is no direct allocation to local government units because, as we would know by the name itself, it's a block grant. No, it's a lump sum,
Yes.
and it is the Parliament that appropriates that said fund to the different programs and services of the Bangsamoro government. And from our experience, ministries would have, particularly those that have provincial offices, would have regular funds allocated to the different local government units that are covered by the Bangsamoro government. And the mandate of all ministries, agencies, and offices, I would think, would cover the whole region. And therefore, in the utilization of the funds and the internal budgeting that happens within a certain ministry or office, there would be allocation to the different areas, but not to give the said funding to the local government unit, but is utilized in the area covered by the local government unit.
Just a follow-up question on that, Mr. Speaker. Did the committee or the proponent consider allocating a minimum cap with regard to the block grant when we talk about local government units. I understand the framework that we are implementing programs and projects at the regional level, and that these are implemented by the line agencies and ministries. But is there not a need to integrate this or explicitly provide a provision that will at least allocate a specific minimum cap of block grant allocation from the regional government to the local government units?
Well, I think the local governance code already provides for the sources of revenues for LGU. So first of all, there would be the national tax allotment, which under considering the Mandanas ruling, would be expected to increase, no? Because the base is no longer the internal revenue, but all the national
Yes.
taxes,
Yes.
tax collections. So that would be one, and that is what is used primarily, no, for the different services of the local government units. Aside from that, there are sharing schemes, as I mentioned, from the collections from the exploration, development, and utilization of natural resources, from the collection of national taxes inside the Bangsamoro region. And as I mentioned, for the appropriation of funds by the Parliament, there would be allocation or appropriation to the different ministries, which in turn would implement their programs in the different provinces, in the different municipalities, because it is the same territory that we are talking about.
Yes.
Except that the powers right now for many of the programs are still with the region, and therefore this law allows us now to transfer some of the powers to the provincial, to the political units, the constituent political units of the Bangsamoro. And I think for the transition, definitely there would be assistance coming from the Bangsamoro government to ensure that the provincial, the municipal, the barangays, the cities are able to execute their mandates as provided in the law.
Thank you, Mr. Speaker. Mr. Speaker, in a nutshell, how do we explain to the local government, in a nutshell, why is there no provision granting them an automatic allocation from the block grant for their programs and projects? You mentioned about the IRA, I think, and the effect of the Mandanas Guardia ruling, and of course, other benefits such as the wealth taxes. Am I right, Mr. Speaker?
Yes, Mr. Speaker. So if you will compare LGUs in the BARM to those that are outside the region, they would actually be getting more, because what the others get are just the NTA.
Yes.
Unlike in our region, where the law says they should get a share in revenues from natural resources, taxes, income taxes collected, and other national taxes collected within the region. These two are not within the privileges of the other LGUs, and yet for the last 30 years, powers that are exercised by them in relation to their constituents, because there is no regional government. It's really the province, municipalities, cities, and barangays that provide services to their constituents. So I guess that is the advantage of being part of the region, aside from the provision that also says that LGUs can also generate their own revenues. They may impose their own taxes, and we have identified the taxing powers of the different levels of LGUs. There's also augmentation coming from the higher LGUs allowed in the BLGC or by the Bangsamoro government, Mr. Speaker.
Just to be fair, Mr. Speaker, the absence of an provision that grants them automatic allocation from the block grant does not also prohibit us from funding programs and projects to be implemented by local government units. And for record purposes, in fact, they are part of the planning of the programs of the regional government. I understand that the governors of the provinces are members of the BEDC. So thank you, Mr. Speaker, for that explanation. My next question, Mr. Speaker, is that under the Bangsamoro Organic Law, Mr. Speaker, what are the shares of constituent LGUs in the exploration, development, and utilization of all natural resources in the Bangsamoro Autonomous Region in Muslim Mindanao? And a question to that, should these shares be released directly to them without need of further action?
Mr. Speaker, as I mentioned earlier, in the matter of the shares of LGUs in the exploration, development, and utilization of natural resources, there are two formulas. And this is provided in section 295. So section 295 says that, let me 295 and give me a minute, Mr. Speaker. Sorry. Okay. I will correct myself, Mr. Speaker. It's the new section number, which is section 307 and 308. So the 50%, so there's a sharing between national government and the Bangsamoro government. And the sharing is either 100% or 50%. So sorry, tama ba? It's 100% for all natural resources. And then for fossil fuels, uranium, petroleum, and natural gas, yes, it's 50-50. Okay, so it's 50-50. For whether it's 100 or 50-50, the 70% of the share of the Bangsamoro government shall be apportioned among the LGUs. The 70% we can we will compute the share for the 50% of the 70%, which is 35%. This will be allocated to all the LGUs in accordance with these percentages. It's 20% for all provinces, 15% for all cities, 20% for all municipalities, and 15% to all barangays. But the other 50% will be allocated in accordance with as I mentioned earlier, where the natural resource that is explored, developed, or utilized is found. So if it's in a certain place, 20% will go to the provincial government, 45% will go to the city or municipality, and 35% will go to the barangay. So if we think about it, the 50% or the 100% allocated to the Bangsamoro government will not go entirely to the Bangsamoro government. Only 30% of that will be retained by the Bangsamoro government, and the rest will be distributed. And then as to how this will be distributed or how we will implement it,
Yes, Ms.
this can be provided in the revenue code, which we should pass as a parliament during the transition, Mr. Speaker.
Thank you for that answer, Mr. Speaker. That would be my last question for that section, Mr. Speaker. But allow me to go back to the previous section which I overlook and skip, Mr. Speaker, section 17, as to the basic services and facilities. I will not read the provision, it's kind of long. But the provision mandates the gradual devolution of basic services. And my question, Mr. Speaker, is how will devolution work in the autonomous region vis-a-vis devolution that is national in scope under the Local Government Code of 1991?
I think, Mr. Speaker, when the Bangsamoro Organic Law, which was passed by Congress, said that the Parliament shall enact its own local government code, it means that the Parliament now has the power to identify principles, guidelines pertaining to local government units, including what powers are to be devolved to the constituent units of the BARM. So we should look first at the law that we will enact as guide for
Yes.
the devolved powers. And maybe suppletorily, we can look at national government if there are still gaps in the law that we will pass.
Thank you, Mr. Speaker. Hindi ko lang na-counter-check doon sa amended ng committee, but dito sa kuan ko 7 years, but yung na-mention kanina 5 years. Why is it 5 years, ma'am, Mr. Speaker?
Mr. Speaker, since for 5 years, the first 6 months, as I mentioned in the sponsorship speech, would be devoted to assessment. So there's going to be an assessment of the financial and technical capacities of the local government units. The next 3 months, not sure, na-finalize. 3 or 6 months, I cannot recall at the moment, Mr. Speaker. There's going to be a transition plan that will be drawn up by a technical working group that is constituted by the devolution committee. So that would already be almost a year, if not a whole year. And thereafter, there will be the actual transfer of power based on the assessment and based on the devolution plan that will be drawn up by the technical working group. And we think that considering that we are starting from a place which is not the same as the other local government units, we may need more time to ensure that financial and technical capacities are there. What we do not want is a situation where the Bangsamoro government devolves, but the local government does not actually exercise the power, and thereby making the constituents of that local government unit without any of the services that are supposed to have been devolved already. So there would be some hand-holding, there would be a lot of monitoring that should happen within that time frame. We think 7 years may be too long, but 5 years would be enough for that. But as discussed in the committee, if the technical working group that's supposed to make the transition plan and the assessment finds that a certain LGU is able to exercise the very next day, then that can also happen. Because as mentioned, as discussed in the committee, there are some local government units, municipal local government units that are more than ready compared to others. And in fact, some of them have already set up their structure in such a way that they are able to exercise, for example, powers over social welfare or health. They have their own social welfare officer, they have their own municipal health officer, which are lacking in other LGUs in the BARM. So that's the transition period, Mr. Speaker.
Thank you for that elaboration, Mr. Speaker. Mr. Speaker, the proponent mentioned earlier that we use the word handhold, and I'd like to ask, what are the challenges of our local government units with regard to devolution vis-a-vis the local government units from other regions or other jurisdictions? What sets our local government units different from those outside the region?
Well, considering that other local government units have exercised most of these powers, if not all of these powers, for more than 30 years, and our LGUs, except for some, have not, means that there will have to be a lot of technical assistance that should be provided by either the higher LGU if they are capable and are ready to help their constituent units, and also from the regional government, because as we all know, the devolved powers that came from national to ARMM then did not get devolved further to the local government units. So for the last 30 years, these powers have been with the regional government. And so that would put our LGUs at a disadvantage if we compare their capacities to other LGUs perhaps that have already been exercising these powers for the last 3 decades. Aside from that, of course, we have regional challenges. We have volatile peace and order situation. We have a lower in terms of socioeconomic development because of the conflict. Primarily, this is much lower compared to the other regions. So we have to work harder in order to get the same level of development compared to others. Aside from the fact that we are also calamity prone, a lot of flooding and other calamities happen in our region.
Thank you, Mr. Speaker. You've also mentioned earlier that there will be capacity building for our local government units, specifically the local government units in the municipal level, and that it should be assisted by the higher local government units. You mean the provincial government? Yes. And then we have the regional government. In the case of the regional government, Mr. Speaker, I know that the ministries that are concerned with the services, basic services, should be involved. But who is the main actor in the regional government when we talk about capacitating our local government units when we talk about devolution? Is it the Ministry of Interior and Local Government?
Well, I think that's also part of the responsibility, Mr. Speaker, of the Devolution Committee, which will be established with the Senior Minister as chair, representing the Office of the Chief Minister. We also have the MILG as the vice chair, since its mandate is really to help local government units within the region. And then we have all the other ministries being also part of the devolution committee. So their task is really to look at the assessment to be submitted by the TWG and then the devolution plan, and also monitor whether the plan is being implemented in accordance with the timeline that should be provided also in the plan.
Thank you,
Mr.
Mr. Speaker. Mr. Speaker, how is this portion of the draft code different from the Executive Order 138, which mandates the full devolution of certain executive functions to LGUs?
Well, first of all, the executive order says that we are exempt, right? It says specifically that the Bangsamoro Autonomous Region is not covered by the executive order, considering the autonomy that we have. Second, that executive order, which talks about a transition plan regarding devolution of certain powers, and I think it specifically looks at what's already provided in RA 7160. So considering that we are crafting our own local governance code, Mr. Speaker, there may be differences in the powers that we are devolving now, because we have a different devolution framework, and we're also talking about not just the additional revenues coming from national taxes, but also the other revenues, no? So there may be more powers that are actually devolved under this law compared to what's in the executive order, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, may I proceed to my next question?
Yes, Mr. Speaker.
Mr. Speaker, I'd like to jump to the, I've skipped other section. May ask them is there a next round of interpellation? I'd like to proceed to section 40, disqualifications, Mr. Speaker. No, sorry, stand corrected. 45 under the new draft, disqualifications. I will not read the provision, Mr. Speaker, but I invite your attention to that particular resolution, provision, section 45. Mr. Speaker, my question is there a
what section?
section 45 in the old in the not amended draft was used to be under section 40, but in the new draft it's 45, I think. Am I right, Mr. Speaker? Yes. Mr. Speaker, my question is there a valid classification between those candidates running for local elective positions in BARM and those in other parts of the country?
Mr. Speaker, may I know which provision specifically the
Letter
question
G.
is connected? Letter G.
Letter G.
Those who are related within the second civil degree. Is that the one?
Yes, Mr. Speaker.
Okay. Yes, Mr. Speaker, this provision says that those who are related within the second civil degree shall not be allowed to run in the same election if the position they're vying for is in the same province as the one of their where their relative is an incumbent, or in the same city, or in the same municipality, or in the same barangay. Mr. Speaker, we have this provision because, as I mentioned, the Congress and the BOL allows the Parliament, being part of the autonomous government, to craft its own law. And I think we have looked at the Constitution as one of the bases for ensuring that we democratize elections in the BARM. We do have a similar provision in the Electoral Code prohibiting relatives from being nominated by the same party. And in this case, since we are given that power, we are exercising it to ensure that we have democratized the choices, of the voters.
Thank you, Mr. Speaker. Does this apply to those who are related by consanguinity and or affinity with members of the Bangsamoro Parliament, whether elected as district representatives or party representatives?
I think the provision says that it is prohibited for relatives who are running in the same province, in the same city, in the same municipality, or in the same barangay. So it's not related to the parliament, elections in the parliament, Mr. Speaker. We're talking about also local government units in this code, Mr. Speaker.
Thank you, Mr. Speaker. I think I am down to my last 4 questions, but I may ask additional questions because I have to counter-check with the amended draft, and my office is still counter-checking the provisions under the new draft. Mr. Speaker, sorry, because ngayon ko lang na-counter-check yung ibang provision. Let me go back to Section 2, Declaration of Policy. Letter C, Mr. Speaker, it says that finally the mandatory public consultations required for the implementation of all programs and projects funded by the national government in the constituent local government units of the BARM shall be governed by policies that may be enacted by the Bangsamoro government, subject to agreement by the national and the Bangsamoro government through the Intergovernmental Relations Body in accordance with Republic Act number 11054, otherwise known as the BOL. My question, Mr. Speaker, is that the national local government units, national local government code rather, prescribes the conduct of mandatory periodic public consultations for the local implementation of national programs. It further emphasizes that these consultations should be made with several groups, including the LGUs themselves, concerning NGOs and other sectors of the community, such as the IPs and local tribes. In the proposed Bangsamoro Local Government Code, we have clearly deviated from the national law and omitted the word periodic and the groups mandated to be consulted with. That said, can we deviate from the provisions of the national LGC? If yes, can we set our own policies re-mandatory public consultations in the region which may be different from those policies prescribed by the national government? What is the disadvantage, if any, of adopting what the national LGC prescribes? Second, are we limiting the powers of the parliament by adding as a condition, sine qua non, the condition of having an agreement between the Bangsamoro government and the IGRB before any policy as to mandatory public consultations are to be enacted and consequently to be implemented in the region? That's
Mr. Speaker, we should read paragraph, what is now paragraph D with what is now paragraph C. Pero mali. Actually, dapat B rin. Ano, tama.
tama ba?
It should be paragraph C.
Mhm.
What section is that?
Section 2, Mr.
C.
Speaker. I think the question is about paragraph D regarding
Sorry.
programs and projects
Yeah.
funded by the national government. But if you look at letter C,
Yes.
since powers have been devolved to the BARM, it says that the Bangsamoro government should conduct the mandatory public
Mm.
consultations with its constituent LGUs
Mhm.
before programs are implemented. And this is different from paragraph D, where national government, notwithstanding the autonomy and notwithstanding the devolution of certain powers to the Bangsamoro government, still wants to implement their own programs. So in that case, we say that before they are able to implement, before conducting or implementing the program, there should be agreements made between national and the Bangsamoro government. I think this is also part of the intergovernmental relations that we want to nurture so that there's full respect for the autonomy of the Bangsamoro government while also allowing cooperation and coordination with national government. Mr. Speaker.
Thank you for that explanation, Mr. Speaker. Mr. Speaker, my next question is under section 3, letter C. Again, I will not read the paragraph. I will just invite your attention to the mentioned section. Mr. Speaker, my question is, what are the instances specified in the BARM local government code which provides for a different appointing authority other than the appropriate appointing authority? Example, mayor, governor, among others, for local officials and employees whose salaries are fully charged against local fund. And under the civil service law, who can remove locally appointed local officials and employees? Who can remove?
Well, Mr. Speaker, one example of employees who are working in the local government units and whose salaries are charged against the funds of the LGU. But as an exemption to this would be local treasurers who are appointed by the Secretary of Finance but are supposed to work in the LGUs to which they are assigned. Otherwise, Mr. Speaker, I think maybe during the transition, there may be employees.
During the transition?
Okay. And also during the transition where certain personnel of ministries may still have to work in the local government units, but hopefully after or within the transition period, there would also be a change in the plantilla of the LGUs because we have in this code a list of the mandatory positions where LGUs are expected to hire their own personnel. Also, there are some officials of different structures, such as in the Secretary of the Sanggunian, the Treasurer of the SK, where the appointment is done by the Sanggunian.
Sanggunian.
Yes.
Thank
Thank you, Mr. Speaker.
Thank you for that response, Mr. Speaker. My next question, Mr. Speaker, is under section 3, letter E. Letter E. Mr. Speaker, section 10, article 6 of the Bangsamoro Organic Law provides that the Bangsamoro government and its constituent local government units, under that, the authority of the Bangsamoro government to regulate the affairs of its constituent local government units shall be guaranteed in accordance with this organic law and the Bangsamoro local government code to be enacted by the Parliament. The privileges already enjoyed by local government units under Republic Act number 7160, otherwise known as the Local Government Code of 1991, as amended and other existing laws shall not be diminished. In the proposed BARM Local Government Code, the MILG is given the mandate to ensure that constituent LGUs faithfully comply with their obligation under pertinent laws. What is the extent to which the MILG can do this without violating the autonomy of the LGUs? That was my first question. Second question is, how can we now differentiate the power of the national government to supervise all LGUs vis-a-vis the power of the regional government to regulate the affairs of its constituent local government units?
Mr. Speaker, when we craft this law, we should still be cognizant of what's provided in the Constitution. And I think that is one of the principles here, that it's not only this law, but all the laws passed by the Parliament should read the Constitution into the law that we are passing. So even if we say that there's supervision by the Chief Minister, we should still read what's provided in the Constitution into this law, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, my next question is Section 6, authority to create local government units. The first sentence is a local government unit may be created, divided, and so on. So on. My question, Mr. Speaker, is this provision was substantially amended by the committee and instead classified the creation, division, merger, and abolition of constituent BARM LGUs, either that of a municipality or a barangay. Under the Bangsamoro Organic Law, the Parliament is given the power to create, divide, merge, abolish, or substantially alter the boundaries of municipalities or barangays in accordance with law enacted by it. In turn, the municipalities or barangays created are entitled to their appropriate share in the national taxes or internal revenue allotment. Now, the national tax allotment. The proposed BARM local government code instead delegated the power to create barangay to the concerned sanggunian with respect to barangays located within its territorial jurisdiction. Can we delegate the powers expressly granted to the Parliament by the BOL? Is there a substantial distinction between a BARM constituent municipality and a BARM constituent barangay with respect to its creation? Why are we choosing to add another condition for the creation of a BARM constituent barangay? Example, the enactment of an ordinance, and none for the creation of a BARM constituent municipality.
Mr. Speaker, I think under the national law, RA 7160, the provincial government, the Sanggunian, may create provinces. Barangays. And we have incorporated that here, that barangays can be created by the province. And in addition, because of the BOL also, and MMAA 25, they may also be created by the regional government. But in addition, the BOL also provides that the Parliament may create municipalities and barangays. What is excluded would be provinces, which
Provinces.
are within the creation
power
of
of
which shall be
Congress.
with Congress. So I
Congress.
don't think there is inconsistency. So we reiterated what's provided in the National Local Government Code, which allows provinces to create barangays. And we've added the power also of the Parliament to create municipalities and barangays.
Thank you for that explanation, Mr. Speaker. That would be my last question for this round, Mr. Speaker. I'd like to thank the proponent for her candor, for the generous accommodation of my questions. Mr. Speaker, may I appeal, though, that I may be allowed to ask follow-up questions? Sir Speaker? Sir Speaker? I'd just like to manifest that while we are while my team is counter-checking the latest draft, that I may be allowed to ask additional questions later on.
Yeah, I will give the discretion to the floor leader on that matter. However, if your questions, your clarifications have already been asked, and we will give you the option to be satisfied with the answer, or you can ask for an elaboration. In which case, you may decide whether or not to ask the questions or not anymore.
Certainly, Mr. Speaker, I will not ask questions that were already asked by my
I think that should be the rule.
predecessors.
That should be the rule. If the questions have already been asked, it should not be repeatedly asked from the chair of the Committee on Local Government.
Thank you, Mr. Speaker. It's a great day. Thank you.
Thank you, Mr. Speaker.
Floor leader, I will recognize Deputy Speaker Hatimil Hassan, who will give a very brief manifestation before I give the floor to the lady from Maguindanao.
I recognize Mr. Speaker. Yes. Bismillahirrahmanirrahim. I would just like to make a manifestation that para mabigyan saysay ang struggle ng Bangsamoro, which has been there for the last 50 years. I would like to manifest that we should avoid any reference to the local government code, ang Republic 7160. Ibig sabihin na tayo kailangan ng magawa ng local government na natin to take advantage yung power and authority that was given to us as a result of our struggle for the last 50 years, Mr. Speaker. And another one, Mr. Speaker, is that sa period of amendment, I'd like to submit yung my proposed amendments sa local government code natin. Thank you, Mr. Speaker. Thank you.
Duly noted.
Thank you, Mr. Speaker. May we request, since there was a manifestation that the Honorable Deputy Speaker will be submitting amendments, just to facilitate during the period of amendments, to give it in advance. Dito na pala. Meron na agad. Okay, thank you, Mr. Speaker. Time check, 11:09. The next interpellator is ready. I move to recognize MP Bayinta ng Patuan.
Yes, the lady from Maguindanao is recognized. Please take note that at the whole time we will take a break and we will come back after lunch. I'm now giving the floor to the lady from Maguindanao.
Thank you, Mr. Speaker. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Mr. Speaker, I would like to begin first with some general questions, then proceed to the detailed line by line, section by section questions on Book 1 and onwards, Mr. Speaker.
The Chair of the Committee on Local Government,
Yes,
please
Mr.
take the
Speaker.
floor.
Yes.
Mr. Speaker, my first question is about the word code. This is the Bangsamoro local governance code. Later on, I'll have some question about the name. But basically, local government code. Mr. Speaker, in the codification of laws related to local governments, when we codify, we put together all relevant laws and issuances enacted by the Congress and promulgated by competent authorities with the Constitution as the overall guiding framework. And then we codify. Are we allowed to, Mr. Speaker, to alter what is provided by law, Mr. Speaker, as a general question?
Mr. Speaker, I'm not exactly sure if I understood the question correctly. Alter what, Mr. Speaker?
For example, Mr. Speaker, with regards to the title, because according to the Constitution, the only mentioned word in the Constitution is local government units. And also in the Bangsamoro Organic Law, the Bangsamoro Transition Authority is tasked to craft the Bangsamoro Local Government Code, Mr. Speaker. This is, minor as we look at it, but I would like to ask further, how do we differentiate Bangsamoro Local Government Code with Bangsamoro Local Governance Code, Mr. Speaker?
Mr. Speaker, if we look at the specific provision of the Bangsamoro Organic Law, there is reference to a local government code in the common noun. So there is, I think it is left to the discretion of the Parliament to call that law whatever it deems fit. It just means that there should be a law pertaining to local governments in the Bangsamoro. We chose local governance instead of local government to ensure that it would reflect the contents which would not be just focused on local governments, but governance as a whole. It would include participation of those who are governed, and not just powers of officials and of the local governments themselves. So that governance is broader. It is not just the structure. It is not just the government, but it's the whole. It covers the processes by which governments conduct themselves and how they also relate with those that they govern, among others, Mr. Speaker.
Mr. Speaker, are we saying that the current local government code doesn't possess what was enumerated earlier with regards to the act of governing and the participation of those being governed?
Mr. Speaker, we're not saying that. Anyway, we are not part of Congress. They may have a reason for calling their that law such, but on our part, the part that we can control, we can name the law in the way that we understand its contents and our intentions, Mr. Speaker.
Thank you, Mr. Speaker. And in proper time, I will propose for some amendments, Mr. Speaker. Mr. Speaker, my second question is about the general picture of the Bangsamoro Local Government Code, Mr. Speaker. They said that in the defunct ARMM, the MMA Act number 25 is 15% copied from the National Local Government Code. And my staff made some due diligence with regards to the draft that was submitted to the Parliament. And it turns out that there are 37 provisions that are new and introduced to the National Local Government Code, and that's equivalent to 6.69%. Those are new. And there was one provision that was deleted, equivalent 0.18%, but the copied with modifications provisions totals 194 sections, which is equivalent to 35.08%. And the copied in toto from the Republic Act 7160 is 321 provisions, or 58.05% of the total provisions. That means to say that under the local government code, there are 536 sections, but under the new, the introduced bill in the Parliament, not the committee report, it has 553 sections. My question now, because the committee have arrived into a report which departs from the original submissions to the Parliament, is there any percentage of how many was further improved by the technical working group or the Committee on Local Government, Mr. Speaker?
Mr. Speaker, unfortunately, I don't have exact numbers, but definitely, as I mentioned earlier, we looked at the National Local Government Code because of that provision also that says that there should be non-diminution of power. So we have to start somewhere. But throughout the whole process, first in the drafting by the MILG, and then in the course of the processes in the level of the committee, we have made some changes, no, to be reflected in the committee report now, considering the feedback and the engagement also with the other ministries and other stakeholders. We are not very conscious as to the percentages, because one change in one provision may have a stronger impact than a provision that has many amendments, but is just a matter of style. So I don't have percentages, Mr. Speaker, but definitely we are looking at an enhanced local governance law that will address some of our or most of our concerns in the region, Mr. Speaker.
Mr. Speaker, can we conclude that the current version, the committee report, is at least 10% of the original version have been revised?
As I said, Mr. Speaker, I don't have percentages, and it's just if what we mean is how many provisions have been changed.
Yes, Mr. Speaker, how many provisions under the current local government code have been changed?
I don't have numbers, Mr. Speaker, and also I believe that it's not very material if we look at the changes that we want to introduce in governance in the BARM. But because, as I said, there may be just a single word that may have changed in one provision, but would have wide-reaching impact, whereas other provisions may have been changed only for style, Mr. Speaker.
Thank you, Mr. Speaker. The reason why I labor on this is because some would say that this is just a copy-paste of what is being provided by the local government code. But we can contest based on statistics that it is not. So that's the reason behind this, Mr. Speaker. Anyway, Mr. Speaker, can I proceed? Mr. Speaker, this is related to what has been asked by MP Mawali, because we all know that the 1991 Local Government Code devolves the powers and functions of the national agencies to the local government units. By devolving another set of the functions of the Bangsamoro government to the LGUs, is this not a redundancy of devolution, Mr. Speaker?
Mr. Speaker, as we all know, RA 11054 provides that the Parliament shall enact a local governance or a local government code. And this law was also passed by Congress, the same Congress that passed the RA 7160, but it came much earlier, meaning considering the autonomy that we enjoy, Congress has provided that for the BARM, Parliament has the power to have its own local governance code, Mr. Speaker.
Ang sunod na tanong ko, Mr. Speaker, kasi sa national government, to tatagalogin ko, Mr. Speaker, nung nag-devolve yung national agencies ng powers and functions nila sa local government unit, nawala na yung tao at saka yung funding. Napunta na sa LGUs. Ito bang in-envision natin na devolution sa local government units, for example, sa agriculture? Mawawala rin ba yung tao ng MAPAR papunta sa mga LGUs at ang yung pondo ng mga programs and projects na nakalaan para sa agriculture and fisheries, Mr. Speaker?
Well, Mr. Speaker, as I mentioned earlier, there is a provision saying providing for mandatory positions. And if you look at the list, there may be positions there that are now within the plantilla positions within the different ministries. So yes, there will be positions that may no longer be appropriate to have in the level of the ministry, in the level of the region, but would be more appropriate to be in the local government units. But maybe not all, and that is why there's in the transitory provision a directive also for the ministries to review their structure and reorganize and restructure if needed, insofar as they are affected by the devolution provided in the code. But there may be other positions that may continue, Mr. Speaker, meaning it's not as if all the powers, for example, over social services would now be transferred to local government units. There would still be powers and services and facilities that will have to be exercised and maintained by regional offices. So there may be a restructuring, there may be a reorganization in the level of the ministries, but such is required for change, Mr. Speaker, in order for LGUs to be empowered and for them to be able to provide relevant services to their constituents, Mr. Speaker.
Follow up on that particular provision, Mr. Speaker. The answer to me was there may be some rearrangement or reorganization, Mr. Speaker. So are we saying that we are not yet certain of what will be the particular programs and projects, as well as the personnel that will be devolved to the LGUs?
Because there are different, this will pertain only to plantilla, to human resources. And I'm saying that I cannot say for each and every power, meaning in relation to health, in relation to social services, in relation to agriculture, that there will be reorganization. But if you compare the plantilla, the mandatory and optional positions that are mentioned in the code to the structure of to the existing structure of the different ministries, offices, and agencies, you would conclude that there will have to be a reorganization. So when the local governance code says that provinces should have a provincial social welfare officer, then that means in the level of the ministry, we do not need a provincial social welfare officer doing the same functions as that to be exercised or to be or within the mandate of the local government's provincial social welfare officer, Mr. Speaker.
Thank you, Mr. Speaker. Now I move to the items of specific sections of Book 1. May I request the Secretariat to flash on the screen the, let's start with section 2. Yes, section 2. From the last version to the committee report, specifically on the new letter C, Mr. Speaker, it says there that it is likewise a policy of Bangsamoro Autonomous Region that regional agencies and offices conduct mandatory public consultations with the appropriate local government units, non-government and people's organization and concerned sectors of the community before any project or program is approved for implementation by the concerned regional agencies, offices, or government-controlled, owned and controlled corporations in their respective jurisdictions. I want the good Minister of Public Works to look at this provision, because in a way or other, it will really affect the implementation of programs and projects. My question, Mr. Speaker, is under the local government code, it says there that it should be a periodic consultations. While in the draft that was submitted to us and even to the committee report, we are elevating it to a mandatory public consultation. Take note of the word that before any project or programs is approved. That means to say, Mr. Speaker, before we can implement a project, and it has bearing on the budgeting, Mr. Speaker, that once the ministry, for example, of Ministry of Public Works would submit a list of projects to the Parliament could ask, has this undergone the mandatory consultation? Because if not, then we cannot allow that to be funded, Mr. Speaker, because we are making it as a mandatory obligation of the ministry to have a public consultation. So is this what we want? Because right now, the burn rate of the agencies without this provision is already low. And when we adopt this provision, Mr. Speaker, I'm pretty sure that it will affect the implementation, Mr. Speaker.
Mr. Speaker, may I respond? Mr. Speaker, in the current budget process, one of the guidelines given by the Ministry of Finance and Budget and Management would be for ministries, offices, and agencies to conduct consultations with stakeholders, including local government units, so that our programs, projects, and activities that are included in our budget proposals would be something that would be needed, in these areas. In the same manner that RA 7160 under Book 1, Title 1, Chapter 1, Section 1, Paragraph C also requires, although it does not say mandatory, it also says periodic, and it also says before any project or program is implemented in their respective jurisdiction. We don't see this as a departure to what is provided in the equivalent law in the national level, nor is it a departure from what is actually related or actually being done by the different ministries, Mr. Speaker. This is consultation, okay? Meaning you have to listen to your constituents on whether a proposed project is something that will not harm them and would enhance the quality of their lives, Mr. Speaker.
Thank you, Mr. Speaker, but still, because I am not a minister, but I used to be a bureaucrat, Mr. Speaker, I know how it takes to implement programs and projects. But just the same, Mr. Speaker, we leave it to the government of the day. After all, it is the government of the day that will be using this, and it has some bearing on the budgeting, Mr. Speaker, later on. And in proper time, Mr. Speaker, I have some proposed amendments. We'll move to
Mr. Speaker, can I just add that, and in fact, an additional process would be in the Bangsamoro Economic and Development Council, where the Bangsamoro Development Plan, the Bangsamoro Development Investment Plan are presented to the governors and the mayors of independent component cities, Mr. Speaker. So I don't think there is any harm in consulting local government units on matters related to projects that are within their territorial jurisdiction.
May I interrupt?
Mr. Speaker, just to frame it, Mr. Speaker, I'm not saying that public consultation will harm any of the ministry and offices. That is a requirement. However, it should be done on a proper time, Mr. Speaker, because it has implication, and even on the layers of who will be consulted matters in the implementation, Mr. Speaker, because we have several layers of local government units. Imagine when you implement the programs and projects. If you consult only the barangay captain, but not the mayor, and not the governor or whoever runs the bureaucracy in there, you have a problem. They can contest that provision, Mr. Speaker, because they can use that as a provision not to implement the project, Mr. Speaker. And that's my problem with this specific
May I interrupt?
provision.
I think there is wisdom in the question right now. There is wisdom which you should consider. And also, I think, are we going to tie the hands of the ministries as far as the matter of implementation is concerned?
Mr. Speaker, I just want to emphasize that this is not a new provision. We just relanguage the periodic to mandatory. And in fact, if you also look at MMAA 25, there's a section saying prior consultations are required. No project or program shall be implemented by government agencies unless the consultations mentioned in this code are complied with and approved by the Sanggunian. So it's even more stringent in MMAA 25. But we have said in the proposed law that there shall be mandatory consultations. There's no need for approval, Mr. Speaker. Consultations would mean that there's a presentation of the project, discussion with the LGU, and since the Minister of Public Works was mentioned earlier, I think they have done that when they planned for the road network in the barn, consulting local government units, Mr. Speaker.
Yeah, in due time, Mr. Speaker, I have some proposed amendments, Mr. Speaker.
Please proceed with your next question.
Okay, wait lang. Section 3. Yung iba, Mr. Speaker, I have some proposed amendments. Diretso na lang. I'll not ask them to I'll submit this one to the committee. I'll just pick some of the points. Again, Mr. Speaker, on the use of the word constituent local government units, which was earlier asked by MP Mawalin, and the use of the word appropriate local government units, can we again differentiate what do we exactly mean constituent local government units, appropriate local government units?
Well, Mr. Speaker, if we go back again to paragraph C, what we used was appropriate because as the intention is for the Bangsamoro government to make the consultation, to conduct consultations with the LGUs that are affected by the project, Mr. Speaker. We don't need to consult everyone, all LGUs in the Bangsamoro if they are not affected by the project. So we use appropriate here because it's pertaining to specific projects and programs that may not affect in the same manner all the LGUs, all the constituent LGUs of the BARM. When we say constituent, that would mean that they are covered or they are within the area of responsibility of the higher LGU or even of the Bangsamoro government, Mr. Speaker.
Thank you, Mr. Speaker. And in relation to the word appropriate local government units, Mr. Speaker, let's put it into example, Mr. Speaker. If there is a road project, for example, in Barangay ABC, Mr. Speaker, in Barangay ABC, what appropriate local government unit would the Ministry of Public Works consult, Mr. Speaker, in relation to defining the appropriate local government units? Just for the record, Mr. Speaker, as part of the records, Mr. Speaker.
Well, Mr. Speaker, there are many things that may figure in this situation. One is whether there is the exercise of the power of the specific ministry is to augment, is an augmentation of the power of one LGU. So for example, the construction of municipal roads may be under the, I'm not sure, I cannot recall, maybe under the power of the municipal government. Then that means when the regional government wants to construct this municipal road, then the LGU that is most appropriate to be consulted would be the municipal local government unit, Mr. Speaker.
And in that case, it's only the municipal LGU, but excluding the barangay and the provincial governor, and maybe later on the district representative when we enact the districting law.
I think so, yeah. Yes, Mr. Speaker. Otherwise, that would mean for each program, you will have to go all the way from the barangay up to the province. So I think it's more appropriate to look at the specific powers of the different levels of the LGU as guide in determining which local government unit should be consulted, Mr. Speaker.
Thank you, Mr. Speaker. That is material, Mr. Speaker, in the interpretation of this specific provision, Mr. Speaker. Thank you. I proceed with, I noticed that as a general, I noticed that there are several use of the ministries, offices, agencies, ministries and agencies, ministries, regional agencies. There are interchangeably used within the entire code. What is the final? What is the generic name that we are going to use in the entire code?
I think, Mr. Speaker, that we usually use ministries, offices, and agencies. And that's just a matter of style. If there are other terminologies that have been used in other provisions, we can clean that up during the period of amendment.
Thank you, Mr. Speaker. And we've noticed also that there are some words in the full text that doesn't use the word constituent in the before the local government units. Are those intentional or just an oversight?
I'm not exactly sure because I think we need to check which provisions. But
Section 12. Can we go to Section 12? There. Yung word na local government units. The national, regional, and local government units are government-owned.
yes, I think for Section 12, Mr. Speaker, we're talking of the specific LGU, and therefore, when we say that, let's speak out provinces, under this provision, provinces are required to set up their own government centers, and where the offices, agencies, and branches of not only the provincial government but of national and regional government may place their office, and even the local government unit of the province, Mr. Speaker. So we don't expect the municipal government, which is a constituent unit of a province, to set up their own office in the provincial government center.
But I think we've seen some later on we can pinpoint it out. Next we go to section 14. Beginning of corporate existence. Under the current local government code, it's a very short provision. It talks here, beginning of corporate existence. When a new local government unit is created, its corporate existence shall commence upon the election and qualification of its chief executive and a majority of the members of Sagunian, unless some other time is fixed, therefore by law or ordinance creating it. But in our provision, medyo dinilit na pala, no? Okay, it's already deleted. So let's move, no? Okay, section 17. So this one is copied in toto. So
Mr. Speaker, for section 17, we deleted the enumeration of powers per level of LG. So our idea is, since book 1 is on general provisions, the specific powers should be provided in book 3 rather than book 1. So it just says under section 17 that we expect local government units to endeavor to be self-reliant and to exercise the powers and duties that are lodged with them. So all the other paragraphs, sub-paragraphs under section 17 have been deleted and have been transferred actually to book 3 on the specific LGU. So it's whether it's barangay, municipality, province, or city.
okay, when we go down there, I have some questions with that. But in the meantime, we can proceed with wait lang kasi mahaba yung dinilit nyo eh. Down. Yung section 22. Section 22.
Yes, Mr. Speaker.
Okay, So hindi kasi natin makikita yung enumeration. But anyway,
Mr. Speaker, the enumeration remains the same.
yes.
These are retained.
But comparing this one with the local government code, yung subsection C says that a contract may be entered into by the local chief executive in behalf of the local government unit, even without prior authorization from the sanggunian concerned. This is contrary to what is stipulated in Section 22, Chapter 2, Book 1 of RA 7160. Mr. Speaker. And also, the Section 22, Chapter 2, Book 1 of Republic Act 7160 use the word corporation, while Bill number 30 uses corporate entity.
Mr. Speaker, may I just address first paragraph C? If you look at RA 7160, under section 22 of Book 1, I think a similar provision is there, giving the same idea, which says, unless otherwise provided in this code, contract may be entered into by the local chief executive in behalf of the local government unit without prior authorization by the sanggunian concerned. Mr. Speaker, and then it goes on to the second paragraph. So it's a replication of what's provided in RA 7160, Mr. Speaker. On the corporate, use of corporate, may I know, Mr. Speaker, which provision? Subsection, saan siya? What section? Okay, on section 22 of the National Local Government.
Wait lang, Mr. Speaker, because letter C of the original version says that unless otherwise provided in this code, contract may be entered into. But in the local government code, unless otherwise provided in this code, no contract may be entered into by the local chief executive. These are two different things, Mr. Speaker.
Okay, we will check, Mr. Speaker, as our copy does not have no. But we will use the same standard as that provided in the national, Mr. Speaker. On section 23, 22, yung use of corporate unit as corporate entity. Because I think, Mr. Speaker, while the LGU has corporate powers, I would not venture to call it a corporation. So we corrected that, but there is no difference. But we corrected the nomenclature to say that it is a corporate entity rather than a corporation, Mr. Speaker.
Thank you, Mr. Speaker. Let's move to...
May I ask, I would like you to clarify that. In our study of, in our study of administrative law, municipal corporations are, municipalities are dubbed as municipal corporations or public corporations. We will break for the war. We will return at 1:30 in the afternoon.
Thank you, Mr. Speaker.
And my question, my clarificatory question should
Recording in
by
progress.
MP Bayintan Ampatuan, Mr. Speaker.
The lady from Maguindanao can continue now with her interpellation of the bill.
Thank you, Mr. Speaker. Good afternoon to everyone. I think the last section that we discussed, Mr. Speaker, is about Section 2 of Book 1, and there was a standing question about the word corporate entity by the speaker, by the presiding speaker.
Well, Mr. Speaker, as we said, there is no legal effect. We're just, we just think that that is the more appropriate nomenclature since they are a corporate entity by virtue of this law. They are not created by to be corporations only. But the effect is still the same. They are corporate entities, Mr. Speaker.
Yeah, the effect is it has juridical personality.
Yes. That is correct, Mr. Speaker.
Thank you, Mr. Speaker. I'll proceed to Section 23.
Yeah, you may proceed.
Yeah, under Section 23, Mr. Speaker, there was a deletion or the changing of national to regional when referring to government and adding the constituent word before local government unit and replacing both houses of Congress and the President with Office of the Chief Minister through the Ministry of Interior and Local Government. Mr. Speaker, this talks about authority to negotiate and secure grants. And in the local government code, there was a provision that talks about assistance that has national security implications, Mr. Speaker, but we remove it. My question, Mr. Speaker, is that what will be the treatment of those projects financed by such grants or assistance with national security implication, Mr. Speaker? Because the BTA Bill number 30 is silent about it. And in the last paragraph of Section 23, it says there that instead of the House of Congress and the President, we changed it to the Office of the Chief Minister through the Ministry of Interior and Local Government. Is it not that the counterpart of the House of Congress is the Parliament in the case of the Bangsamoro, Mr. Speaker?
Mr. Speaker, can we just break down the question? The first one being
Projects with those grants or assistance with national security implication, because the current bill is silent about it.
Mr. Speaker, with respect to that part of Section 23, we changed the reference to national agency to the regional agency. Since we cannot bind national agencies, particularly in relation to financial grants and donations, Mr. Speaker. And if there is any issue pertaining to national security, I think we are in agreement that it will still be national government that has that power, Mr. Speaker. So that if there is actually a program or a project that will require approval by national agency because of a security concern, we will respect that power or responsibility, Mr. Speaker.
So in this case, Mr. Speaker, we are saying that if there are programs and projects that may come from outside with national security implication, everything should be in the hands of the national government.
Yes, if there are national security implications, Mr. Speaker.
Yeah, may I interrupt? What can we be enlightened what kind of programs that has national security implication?
There are funding, Mr. Speaker, that might be contrary to some national policies that may be entered into the Bangsamoro government. The question is, how do we treat those kind of assistance, Mr. Speaker?
And in fact, Mr. Speaker, that the counterpart provision in 7160 says that when there is no approval by the national agency and there is silence on the application or the seeking of approval, it will be deemed approved. And that is the reason why we also took it out of the version that is found in the BLGC. We cannot bind national agencies in that way, Mr. Speaker.
So in effect, Mr. Speaker, we cannot receive direct national and direct foreign assistance with some sort of security implications with this provision, Mr. Speaker.
Can you, Mr. Speaker, maybe hear the question once again?
In effect, Mr. Speaker, because we are silent about this, we cannot receive such grants or assistance coming from outside with those quote unquote with security implication without passing it through the national government. So directly we cannot accept, Mr. Speaker.
Yeah. So our answer is the same, Mr. Speaker. I think if there's national security involved, we will have to bring in the national government.
Yeah, thank you, Mr. Speaker. Just for the purposes of reckoning later on if there are questions about this provision because we are silent about this. Thank you, Mr. Speaker. Now, on the question, second question, it doesn't talk about the parliament, but in fact, the local government code talks about the House of Congress.
Mr. Speaker, I think it springs from the concept that it is the chief minister that has supervision over local government units.
But Mr.
Well,
Speaker,
While the power of regulation or regulating the affairs would be legislative in nature, and it covers the act of enacting or it covers the enactment of the Bangsamoro Local Governance Code. Thereafter, it's the chief minister that has direct supervision over the higher LGUs, Mr. Speaker.
that means to say, Mr. Speaker, this is because this is about reporting, Mr. Speaker. In effect, the Parliament will not be informed of anything with regards to the kind of assistance that will be coming in to the Bangsamoro government. This is the implication, Mr. Speaker. Are we saying that the Parliament should not know those kinds of assistance, Mr. Speaker?
Yes, I think, Mr. Speaker, we cannot make a parallel comparison since in the case of the national government, there's separation of executive and legislative. So in our case, the chief minister is part of the parliament, and reporting to the chief minister would involve also the parliament. Considering the fact that the fact which I mentioned earlier, that it is the chief minister that has supervision over LGUs. So we
Anyway,
put
Mr.
that
Speaker,
together.
I have some reservation with this provision, Mr. Speaker, and in due time I have proposed amendment, Mr. Speaker. Let's proceed to Section 24 is just copied, except we inserted the word constituent local government. Section 25 is we just replace national with regional. We replace the president with the chief minister. And I have a question with regards to Section 25, Mr. Speaker. On item C, Mr. Speaker, because subsection B, Section 25 of Bill number 30 was patterned after Section 10, Article 6 of RA 11054 or the BOL. It provides in part that the authority of the Bangsamoro government to regulate the affairs of the constituent local government units shall be guaranteed in accordance with organic law and the Bangsamoro Local Government Code to be enacted by the Parliament. The question, Mr. Speaker, is on item C. Will it not diminish the existing power of the local government units? Because according to the provision under letter C, the implementation of all national policies and standards concerning the constituent local government units shall be agreed between the national government and the Bangsamoro government as may be prescribed in the intergovernmental relations mechanism. So, in effect, Mr. Speaker, the LGUs, the kind of the kind of policies that may be agreed upon by the national government and the Bangsamoro government may not be reflective or may diminish the existing powers and functions of the local government units.
Mr. Speaker, can we ask the Secretariat to flash the specific provision?
Deleted.
Yes.
You deleted
Mr.
it.
Speaker. But there is a separate section on that, under section 30. So there is a section 30, paragraph C, which says that there shall be coordination between agencies, ministries, and offices of the Bangsamoro government as well as local government units
It's okay.
concerned
It's
in the
okay. So
implementation. of
there's an
project.
involvement of LGU.
Yes.
Okay. And on letter D, what happened to letter D? Can we go to section 23? Yung letter D ba yun? Anong section yung kanina?
It's also in section 30, paragraph B. Are you referring to the establishment of sub-regional offices, Mr. Speaker?
Yes.
So it's now in section 30, paragraph B. The Bangsamoro government may, by law, establish sub-regional offices in the constituent LGUs as it may deem necessary.
My question here, Mr. Speaker, is that we intend to devolve the powers and functions to the local government units, Mr. Speaker. The question then is, what is the purpose of creating such structure when in fact we are devolving the powers and functions to the LGUs? Will it not become redundant? The services will not become redundant, Mr. Speaker?
Mr. Speaker, I think we can look at what is currently practiced by national government, notwithstanding the devolution of certain powers to LGUs. So DSWD, for example, has regional offices. So in the same way, because there are programs and projects that are managed and implemented by the Department of Social Welfare and Development. And it is much easier to implement that through field offices. So this way, the Bangsamoro government may still have, particularly in the transition period where devolution may not be fully implemented, and you will have programs that you have to continue, and it will be much easier if you have field offices rather than operate from the regional level.
Mr. Speaker, the way I understand it, based on Bangsamoro Autonomy Act number 13, we have defined structures from region down to the province, down to the district, and even to the barangay when in terms of education. Are those structures not yet sufficient and requires us to create another substructure, which is the sub-regional offices, Mr. Speaker?
Well, Mr. Speaker, it says may, it does not say it shall. When necessary, and when it is more convenient so that programs can be effectively implemented, there is that option. Sub-region it just means it's lower than the regional level. It can be just, even in the BOL, we have sub-regions on mainland, and we have southeast, southwestern, and all.
Mr. Speaker, the follow-up question, Mr. Speaker, is this in effect amend some provisions of Bangsamoro Administrative Code, because under the law, the structures of the ministries and offices are defined, Mr. Speaker.
Yes, Mr. Speaker, we have said that in our sponsorship speech that ministries may have to reorganize and restructure considering the devolution that will be affected.
Okay, then we proceed to to 26. May mga comments lang, small comments lang, but I'll give it to you. We'll move to Title 2. Okay, Title 2, Section 39. It's about qualifications. Although this has been initially discussed by MP Mawalid, this particular section is patterned from Section 39, Chapter 1, Title 2, Book 1 of Republic Act 7160 with modifications. And there are further modifications from the committee. Because Mr. Speaker, under the Constitution, Mr. Speaker, it does not provide for educational qualifications for any elective officials, at even to the highest elective position of the government. Basic question, why provide such qualification in the proposed bill? Is it not unconstitutional?
Well, Mr. Speaker, I think the committee report states that, well, the amended bill in the level of the committee has no provision pertaining to educational attainment anymore. It has been deleted, Mr. Speaker.
So what we have now is a pattern from the local government code.
Yes, Mr. Speaker, although in relation to, well, not qualifications, but there is now a requirement for mandatory training and capacity development. But because in the deliberations, we recognize that there may not be direct correlation between educational attainment and the capacity to hold positions in the local government. Mr. Speaker.
Can we look at the other text of the qualifications? Yun na ba yun? So we deleted the educational qualifications.
Yes, Mr. Speaker.
Okay, thank you. Next is on disqualifications. Disqualification, Section 40. Retained. So everything is retained. Mr. Speaker, Section 40, Chapter 1, Title 2, Book 1 of Republic Act 7160 was copied in toto. However, there are new provisions added in the proposed bill number 30. For example, subsection G, H, and I G, ano na yung nangyari sa G?
It has been amended, Mr. Speaker.
So, can the proponent explain to us just for information, because I think this is a crucial provision for us for everybody to understand this particular section.
So, Mr. Speaker, under paragraph G, we retain the provision that those who are related within the second civil degree shall not be allowed to run for the same in the same election for the same local government unit. Okay?
Pwede
Ah.
bang paka-explain ng
So kung
mas concrete kung ano yung ibig sabihin ng second degree?
okay, kung
Example.
kung second degree po, ang kasama po dito ay ang ating asawa, ang ating magulang, ang ating anak, at ang ating kapatid. At yung mga asawa nila. Okay, so by affinity. Kinlaro lang po natin sa unang bahagi na whether full or half blood, lalo na po sa mga polygamous na relationships, you may have siblings who are not related to you in relation to one of your parents. Correct? Sabihin may kapatid ka na anak ng tatay mo sa ibang nanay,
Pwede yun.
ibang babae.
Hindi
So
pwede.
kasama po yun sa bawal.
Bawal.
Apo. So
Okay.
full and half blood.
Sige, maiging maintindihan natin ito, no? Kasi this has been a case prevailing in the Bangsamoro Autonomous Region. So, bawal yung asawa, kapatid, tatay, nanay, anak, asawa ng
At
all those things, at
idadagdag
apo,
po,
at
at
apo,
lolo.
apo at lolo. So, yun ay mga bawal pag isang posisyon na isang lugar lang sila.
Hindi kailangang isang posisyon, pero isang posisyon sa parehong local government.
Halimbawa, mayor.
So tatakbo si tatay ng mayor, tatakbo yung anak na konsehal, hindi po pwede
Hindi
yun.
po pwede yun. And all those other individuals, hindi pwede.
Apo.
Pag tumakbo na yung isa sa pamilya,
Apo.
dapat pupili lang sila ng isa.
Yes.
All those related to him or her is already disqualified.
Yes po. So yung unang talata po, ang sinasabi niya ay may incumbent, tapos may kamag-anak na gustong tumakbo.
Tumakbo.
Si kamag-anak bawal ng tumakbo dahil merong si incumbent na tatakbo rin. Sa pangalawang talata po, kapag ang mga kandidato ay hindi mga related sa incumbent pero sila ay magkamag-anak, wala po sa kanila ang pwedeng tumakbo. Sa unang talata, yung incumbent ang bibigyan ng
Those related.
yes, yung mga bawal ay yung mga kamag-anak.
Kamag-anak.
Pero kasi yun lang ang original na provision. So ang tanong doon ay paano kung hindi naman sila related sa incumbent pero sila ay magkakamag-anak. Kaya po may
Bawal
pangalawang paragraph.
So bawal din yun.
Apo.
Basta kamag-anak.
Yes po. Silang dalawa na ang bawal.
So ang maigi kong maitanong, Mr. Speaker, ay wala ba tayong nilalabag na batas sa paglagay natin itong provision na ito? This is really promising. No? This is really important to us and I think this will help us. But I know that in the current setup and in the current practices, mukhang mahihirapan, no? Sumunod dahil halos lahat ng nasa munisipyo ay magkakamag-anak, no? So, wala ba tayong nilalabag na batas kung ito ay ating isusulong, mahal na Speaker?
I think, Mr. Speaker, in fact, we are trailblazing in the sense that we are putting into law what is already provided by the Constitution in 1986, Article 2, Section 26, which states that the state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law.
Second. Where they all incumbents but are related to one another within. Sige. So wala tayong malabag, no? Base sa provision ng Constitution.
Yes.
Kasi maiging maintindihan natin lahat para tayo lahat magdidepend dito dahil in event na ito ay i-question, lahat tayo alam nyo yung ay sasagot, no? So malinaw na may may merong provision sa Constitution na nagpo-provide ng equal access and opportunity to everyone.
Yes po.
Thank you very much, Mr. Speaker.
Idagdag ko lang para lang klaro. Kapag naman po lahat ay incumbent, pare-pareho rin pong hindi pwedeng tumakbo. So, ibig sabihin, dapat din tulad nung sa unang talata, ang solusyon dyan ay dapat mag-usap ang pamilya kung sino ang patatakbuhin. Second, na gusto ko pong sabihin sa ngayon ay itong ang nababahala. Kaya meron po tayong moratorium until the end of parang meron tayong devolution period, di ba? Parang may transition. Same here, para po alam ng mga pamilya that there will be this rule that will be applied not in the next election, but in the
Pwede bang mabasa
succeeding
natin yung sinasabi, Mr. Speaker, about the moratorium? Pakita
It's
natin.
in book 4, I think.
Book 4. Bakit kailangan nating ihiwalay, Mr. Speaker?
Kasi transitory provisions po ang
provision.
4, yes po.
Ilang taon ba yung ating
Devolution, 5 years.
hindi po, yung ating moratorium?
5 years din po.
5 years.
Pareho po nung...
Ano po yung basihan natin doon sa 5 years? Bakit natin ginawang 5 taon?
Dahil ang susunod na eleksyon ay hindi po muna natin isinama. So naging 5 years po kasi ang susunod na eleksyon na uli
ay
for local
2028.
government
Ay 2028.
units ay 5 years from today.
From now.
Apo.
So 2028, in effect na yung batas natin.
Yes.
The moment we approved
Apo.
this BTA Bill number 30.
Yes po, ayan po yung transitory provision.
Pwede bang
May I be clarified? It will not yet be 5 years on May 2028.
June 2028.
Hindi pa. So hindi pa sa plus 3 pa.
Okay.
28, 29,
It will be
30, 31.
2031.
5 years from the effectivity of this code. So,
So-
2023 plus 5 is 2028.
Yes, but
24,
on the next
25,
election, it will
26,
be
27, 28.
May 2028.
Hindi pa
So
siya mag
we
5
can-
years.
We can clarify that we are pertaining to the elections that will be held 5 years from now.
So maybe we can improve the language,
Yes.
Mr. Speaker.
Yes, Mr. Speaker.
Okay. Sige. Maiging maliwanag yun sa ating lahat because kailangan nating dumipensa lahat, no? Once this bill will be in question. So we'll move to 41 is okay. 42, copy din toto. 43. Pwede bang masilip yung section 43, yung final language? Section 43, no? The term of office of all elected officials shall be 3 years, starting June 30.
So we have deleted the optional term. So
Pero po sa both the 7160 and RA 8524, which amended the former particularly on in terms of office of barangay officials and members of Sangguniang Kabataan, provides that the term of office of barangay officials and members of Sangguniang Kabataan shall be for 5 years. Pero yung atin ay 3 taon.
I think the latest rule is also is for the SK and the barangay to have 3-year terms.
Ano pong batas yun,
As-
Mr. Speaker?
Well, it's RA 9164 and SK Reform Law RA 10742, and this was affirmed by a Supreme Court decision, Comelec versus Conrado Cruz, which says that the term shall be 3 years.
So ito po yung latest.
Yes po.
Okay. Then we'll move to vacancies, 44. Ano yung final ng 44? So nag-depart na tayo doon sa... Pwede pong paki-explain bakit natin pinalitan?
So in paragraph A, Mr. Speaker, when there's a permanent vacancy in the position of the chief executive, it is the vice mayor or vice governor who shall become the governor. Okay, that's paragraph 1, paragraph A. But if the vice governor or the vice mayor is also permanently unable to succeed, then it is the highest ranking sanggunian member who shall take the position. And the second highest will now become the vice. Sorry. Okay. Anyway, it's the rule of succession is governor. If he or she becomes permanently unable to serve, it is the vice mayor who becomes governor or mayor. If that person is also permanently unable, it is the the first highest ranking sanggunian member, and so forth. No, from first to second, and down the line.
So tinanggal na natin yung pagbanggit ng disqualification? Wala na siya. Okay. Okay.
Yes, so that's paragraph A. In paragraph B, we're talking about vacancy in the position of punong barangay. Since there is no vice punong barangay, it is the highest ranking sangguniang barangay member who takes the punong barangay's position in case of the latter's inability. And therefore the same thing, no? If that person is not able to take on the position, it's the next highest ranking.
When we say next highest ranking, dahil puro sila sanggunian at sinasabi sa local government code ay may drawing of lots. Yung sa atin ay paano natin ma-determine yung highest ranking?
I think if it's just one district, you look at the number of votes that they garnered.
So based on the number of votes?
Yes.
Okay. And on letter C,
I don't think there's a drawing of lots even in the local government code.
It's provided under the local government code.
What section?
Section 44.
I think it's like, I don't know what section this is.
It's section 44.
When there is a tie, but if there is none, then it's based on the votes that you garnered.
Yes. And on letter C of the PAL bill,
Mhm.
carried ba to?
Letter C.
Yes. Okay, minor lang.
Yes.
Splitting lang ng ano. Okay na.
The lettering, the
Okay.
letter.
Yes. Oh. Next is on Rapid in Toto, new provision. Wait lang.
Let me just clarify,
Clarify.
Mr. Speaker, that if there are districts in one province or city, the ranking will be based on the percentage of the votes that they got in relation to their district.
In relation to that, Mr. Speaker, speaking of the parliamentary districts, have we included
No,
that?
Mr.
Not
Speaker,
yet.
we have deleted that whole
Parliamentary.
article on parliamentary districts and the succeeding article
Because
it's not local government. It should be another law that
Should-
should provide for parliamentary districts. It's about election in the parliament. So they are not local government elections.
election. Okay, let's move to section 55 on quorum. The added provision, subsection D. There's an added provision, subsection D. Did you retain that?
Section 55?
D, yeah. So na-reword na, no?
Yes.
So
So here, Mr. Speaker, section 55.
can we have a discussion on this because
Yes.
this is
So,
material.
Mr. Speaker, the question, paragraph D,
Letter D, letter D,
delta.
delta.
Okay, so we're saying, Mr. Speaker, that just like in the National Local Government Code, Sangguniang members who do not attend sessions for 4 consecutive times and there is no justifiable reason, they will be excluded from the computation of quorum. And also those who have been subjected to preventive suspension. So if there are, for example, 10 Sangguniang members, or let's say 8, and one has not attended for 4 consecutive sessions, and then another one has been put on preventive suspension, then the quorum will be based on 6 and not 8. Because the 2 are not able to attend anyway because they are under disciplinary action. And we will adjust the base for the computation of quorum, Mr. Speaker.
Okay. Next is on More. Um,
₱63.
may changes ba? Or
Mr. Speaker, under Section 63, which is now Section 70, we clarify that for administrative complaints, this shall be filed with the Office of the Chief Minister, considering that he has the general supervision power.
so we remove the true MILG.
Yes, Mr. Speaker.
And for Sanggunian,
So the Office of the Chair elected officials of one province, two, a highly urbanized city, or three, an independent component city. But if the airing or the official being complained of is an elective official of a municipality or a component city, the one that has jurisdiction is the Sangguniang Panlalawigan, the province. And for the barangay officials, the jurisdiction lies with the Sangguniang Panglungsod or Sangguniang Bayan, Mr. Speaker.
and for letter D,
For letter D, okay, this one is a situation where filing the complaints to the higher sanggunian will not result in a fair or just resolution of the complaint. So under letter D, the Office of the Chief Minister is given concurrent powers as those provided to the Sangguniang Panlalawigan, Sangguniang Panglungsod or Bayan, or Sangguniang Pambayan. So, yes, Mr. Speaker.
and this only happens when there are complaints coming from ABC.
Coming from B and C, Mr. Speaker, because under paragraph
Yes,
A,
D and C.
it is already the Chief Minister
Yes.
that has the jurisdiction.
And any of those aggrieved party may file
May file to
complaint to
straight to the Chief Minister.
directly to the Chief Minister.
Yes.
May I be clarified? In the Sangguniang Panlalawigan and in Sangguniang Panglungsod, the decision on a question of tax is final and executory? No, it's already deleted. It's already deleted.
We've deleted those, but let me just check.
Okay,
I think there's a remedy for an appeal to the higher sanggunian for all matters.
so hindi na-reflect yung remedies.
Let me see.
I think it's
Maybe
reflected.
it's
Where?
reflected already.
Section 69, which is now Section 78.
So later, okay.
Yes.
So
Mr. Speaker.
dito na muna tayo. But merong remedies bago
Yes, Mr.
bago aabot kay Chief Minister.
Yes po.
Okay. Let's move to 64. 64. Ano nang final dyan? Nandiyan pa
So-
ba yung hearing officer?
So we did not include the hearing officer, which is provided, I think, in Section 63. Mr. Speaker, we just said that the Chief Minister shall issue rules governing complaints, administrative complaints filed with them. Under Section 71, it says that the notice shall be given to the respondent within 7 days from the filing of the administrative complaint. And that the respondent shall be given a chance to file his or her verified answer within a non-extendable period of 15 days. And that the hearing and investigation shall commence within 10 days from receipt of the answer of the respondent, Mr. Speaker.
Mr. Speaker, on letter B, why we delete letter B?
B of section, yes. Yes, Mr. Speaker, because we have a new section. So we separated the venue from the notice. So if you go down, please, Secretariat, there is a new provision that's on venue specifically, which is covered by paragraph, what was originally paragraph B. So it says that when the complaint is filed before the Chief Minister, the venue shall be that determined by the hearing officer. But if the complaint is filed before the Sanggunian, the venue will be the place where the Sanggunian holds office.
When we say hearing officer, who are we referring with?
Well, we stated, Mr. Speaker, under Section 63 that the Office of the Chief Minister shall issue the rules pertaining to administrative complaints, because I don't think it is the Chief Minister who will conduct the investigation. So there has to be someone who will hear the administrative complaint, and that will be
found.
That will be provided in the
guidelines.
to be issued by the Chief Minister, Mr. Speaker.
But we haven't included in the provision the subject of
Having
a guidelines.
It's in Section 63, Mr. Speaker.
Section 63, may we look at it?
The last paragraph, paragraph D. Go down, please. For A and D, the Office of the Chief. Go up, please. Okay, stop.
Ayan na. Yan na. Doon sa
Go
taas.
down.
Taas, yan.
Stop, please, stop. For A and D, the Office of the Chief Minister shall issue the rules governing the procedure for administrative complaints filed under this section.
Okay. Next is Lapit na. Lapit na matapos yung bukuan. Yung section 72.
Session suspended. 1 minute.
Kapal-kapal ng libro ko. Hindi pa ko nakapag-aral.
Floor leader.
Thank you, Mr. Speaker. May we continue with the interpellation by MP by Intan Ampatuan?
The lady from Maguindanao may now continue his interpellation.
Thank you, Mr. Speaker. On Section 72, Mr. Speaker. So there was a deletion of. So basically my question is the deleted portion, Mr. Speaker, so we can move to other section.
Yes, Mr. Speaker, with respect to recall, there was a law that was passed after RA 7160, deleting or providing for only one way of initiating recall proceedings, a recall process. So it did away with the preparatory recall assembly as a mode for initiating recall and only retaining the petition modality as a way of initiating recall elections.
Thank you, Mr. Speaker. Can we move to Section 78? So we deleted the last paragraph, or yes. Actually, my question was on the last paragraph. So we deleted that already. So no question. Then on Section 83, Mr. Speaker.
Section 83, now Section 93.
Yes, Mr. Speaker. So there was deletion already. So let's move to other, because my question is on the deleted provision. On Section 91.
Section
91. This is a copy retained. So this is a copied from Section 89, Title 3, Book 1 of RA 7160 with added modification. They added the paragraph 6, subsection A. However, it has reference to Section 60 of the Bill 30. I guess only referencing ang problema. So I can forgo that. Okay, Section 94, oath of office. So what about the oath of moral governance, as we included it in the administrative code?
Mr. Speaker, what we included would be the oath of office, which is the legal requirement, but the local official may choose to take the oath of moral governance if he or she so chooses, Mr. Speaker.
Mr. Speaker, are we saying that the oath of moral governance as embodied under the Bangsamoro Administrative Code is optional?
Well, Mr. Speaker, I think even the original version, BTA Bill number 30, which is the basis of our deliberations, talk about taking an oath or affirmation. And we simplified the provision to say that it's still required, and we did not touch on the oath of moral governance, Mr. Speaker.
Yes, Mr. Speaker, but based on the original text of the filed bill, it even says there that swearing it before the Holy Quran and not the oath of moral governance. So there was actually an intent to incorporate in the original version a much higher version of it, because it talks about the Holy Quran. But just to be consistent with what is provided under the administrative code, why not, instead of the Holy Quran, mention the oath of moral governance?
I think, Mr. Speaker, Section 94 only talks about the oath or affirmation of office. So even the original, which is a requirement for officials before they assume office to take the oath of office, and we've included affirmation. But this is not about the oath that the good MP is talking about. Not even in the original is it provided. So we did not delete anything on that, Mr. Speaker.
Deleted the Holy Quran.
Yes, but that's not the oath of moral governance. We can we can put back the holy books because it is an inclusive language. Not only will it cover those who profess by or follow the Holy Quran, but other holy book, other holy books recognized by other religious associations.
But Mr. Speaker, just to be consistent, no, and I don't know exactly nung nakalagay
Qualification into office.
Yes, Mr. Speaker.
I think that should clarify the cloud on that provision.
Okay, then we can move to section 95. The next to that. May tinanggal ba?
95. We've added
May tinanggal.
provide. We did not delete. I think we added.
Can we go down?
The capitalized phrases.
Okay, so tinanggal na yun to be enacted. Okay. And okay, let's move to
May be clarified again on this. When he takes a leave, is this mandatory or voluntary on his part?
Well, Mr. Speaker, there's a requirement generally for local for government employees to not participate in partisan political activities. We made an exemption for those who will be nominated under the party representation, under the party list, and under regional political parties. So in order for that person to undertake or to take part in partisan political activities, he or she will have to take a leave from the office. And yes, Mr. Speaker, that's the idea.
yung last sentence lang, yung added, yung provided that this shall not apply to local officials or employees in the career civil service who are nominated as party representative. We are repairing here of the solicitations.
Yes, Mr. Speaker.
So they can solicit?
Yes, Mr. Speaker, but I think you have to also read that in conjunction with the other proviso.
That means to say,
That means to say they will have to take to take a leave of absence, Mr. Speaker.
so leave of absence, or if they are permanent employees, they should resign.
No, Mr. Speaker. In the electoral code, we've allowed even permanent employees to continue being permanent employees, but during the period that they are running for office under the party representation, they will have to take a leave. They will not be considered resigned.
Well, I think medyo, I don't know the civil service rules about this.
Kaya nga.
But is it provided in the electoral code? And we know that the electoral code is now being questioned in the Supreme Court. But nonetheless, maybe we can reconcile this with the civil service law with regards to officials, government officials and employees who will be taking part of political activities, no? So I have my reservation on this, Mr. Speaker. Next is on #98, retain. So yung question lang na everything should course through the permit to travel to MILG. So yung in terms of translating this one into real action, pag ang isang mayor ay maghingi ng travel authority papunta sa, for example, pupunta siya ng Japan, so mag-a-apply siya sa MILG. Ang MILG ay i-endorse niya sa Office of the Chief Minister. Meron ba tayong sinabing guidelines on how to execute this in order to ensure that the same requirement of the local government units will not be delayed and magamit nila yung requirement na yon para sa kanilang pangangailangan?
Well, Mr. Speaker, I think as to details as to how permissions or applications for travel authority will be executed can be provided in the implementing rules and regulations, Mr. Speaker. Please also, Mr. Speaker, let us take note of the very specific situations where paragraph C applies.
Okay, and in that case, Mr. Speaker, I have a question with regards to the IRR. Are we saying that after we pass the Bangsamoro Electoral Code, and in the last portion of this code, of this bill, did we put a provision that an implementing rules and regulation shall be crafted by concerned institution within a certain period of time?
Yes, Mr. Speaker, it's in Book 4. MILG is directed to issue the implementing rules and regulations with consultations with the stakeholders, including ministries and local government units. Mr.
So that
Speaker.
in effect, Mr. Speaker, while it will be enacted, it's not yet binding and implementable, pending the approval of the implementing rules and regulations.
Just like RA 7160, Mr. Speaker, which also has a set of implementing rules and regulations, yes.
Thank you, Mr. Speaker. I think that is a very important point that we need to know, Mr. Speaker. And let's move to Section 99. It's retained. The question here is what if the annual report is not complied? Are there penalties or consequent action from the MILG, like recommending to other ministries for suspension of payments of BARM-funded projects?
We did not include that, Mr. Speaker. We may, the good MP may want to propose that, or it may be included in the implementing rules that may be issued if there is going to be some process pertaining to non-submission of annual reports.
I think this is very important, Mr. Speaker, because we are devolving some functions to the LGUs, and they should be accountable to the resources that are given to them. So there should be, it is a must for them to submit report to the Bangsamoro government, Mr. Speaker.
Well, Mr. Speaker, on that matter, I think considering that immediately after the enactment, there will be a devolution committee that will also look at the progress of devolution. There will be constant coordination with the local government units, particularly on the devolution of powers, Mr. Speaker.
But just the same, we want to ensure that reports should be submitted because right now, I don't know if there are LGUs that are submitting reports, no? Okay, so let's move to move to section 102. This is a copied version from the local government code. However, there are some modification by instead of meeting at least once a month as provided in the local government code, the local school board in the proposed bill provides that the LSB shall meet at least once every quarter. I think why do we need to lessen the number of meetings? Because this one is a frontline service. They need to convene at least every month in order to ensure that the issues affecting education will be outrightly answered by the board.
Mr. Speaker, I think for the school board, they are expected to look at policies, not really implement education programs, but policies and augmentation of funds or budget for education. And in our understanding, Mr. Speaker, quarterly meetings is more, having quarterly meetings is more viable, Mr. Speaker.
Mr. Speaker, was there a consultation with regards to with the local school boards, for example, of one area, province, or city, and they recommended that instead of having a monthly meeting, and it should be on quarterly basis, as our basis in saying that this meeting should be not as frequent as embodied in the current local government code.
I think, Mr. Speaker, nothing will prevent the school boards to meet more often than every quarter. Since Section 102 says it may meet every quarter or as often as may be necessary. We're just saying that the minimum number of meetings can be reduced to 4 in a year, Mr. Speaker. But they can meet monthly or even more often than that.
Okay, so let's proceed to (104), composition, creation and composition. On paragraph 4, section B, subsection B, Paragraph 4, subsection B.
On the functions, Mr. Speaker. I think it's not subsection B of paragraph
There is
4.
a say, there is a committee there which serve as a planning body. Planning body.
Which paragraph, Mr. Speaker?
Paragraph, paragraph A4. No. A4, na. Paragraph 4, subsection B.
Functions.
May committee dyan. Wait lang. Ayun. Yung 4, yung sa dulo. Pinakadulo. In case of local government unit whose health services are not fully devolved, the committee shall serve as planning body. Anong committee yan?
I think we've changed that to the board.
The board. And the board is the local health board?
Yes, Mr. Speaker.
Maybe we can put the local health board instead of the board in due time, Mr. Speaker.
It's okay, Mr. Speaker, although it's under section 104, which it talks about local health boards, and the title is "There shall be established a local health board." The whole title is local health board. Yes. Anyway,
Okay.
Mr. Speaker.
In on section 106, Mr. Speaker, it says there that the chairman and the co-chairman and vice chairman, as the case may be, and members of the provincial, city, or municipal health board shall perform their duties as such without additional compensation. Do they have a compensation already?
Because, Mr. Speaker, the chair is the municipal or provincial mayor or governor, the municipal health officer, and therefore they do get compensation as local officials of the local government.
Okay, thank you, Mr. Speaker. On section 107, includes the provision about the national government in public health dangers in the region. Is the proposed last paragraph acceptable to the national government? Did we consult the national government?
Well, Mr.
When
Speaker,
we say national government, what office, department, or what office or department we exactly refer to?
well, Mr. Speaker, this does not give any obligation on the part of national government. This is just saying that the local government, in cases of widespread public health dangers, including epidemic and pestilence, may request the national government, Mr. Speaker. Yes, there is no obligation on their part, Mr. Speaker.
Yeah, because the section talks about direct regional supervision and control of the Minister of the Ministry of Health.
I think it's about supervision and control over health operations in affected localities.
Because the one I'm talking is a new provision from the local government code. And it seems to me that it is not directly congruent with the title.
I think for the first paragraph, it is about the Ministry of Health and the Minister of Health.
I'm talking about the last portion.
Yes, the last portion is about widespread public health dangers, in which case there may be a request on the part of the Bangsamoro government for assistance or for direct intervention from national government, Mr. Speaker.
I guess
Taking
my
off also from our experience in the COVID, in the period where we had COVID, Mr. Speaker.
okay. I guess my concern is the title doesn't capture the entire provisions, Mr. Speaker. Anyway, let's move to 109, composition of local development councils. It says there that unless composition, 109, not 108. It says there that a representative from the parliament.
Yeah. Yes, Mr. Speaker. Under number 4 for the barangay.
So this will be decided upon by the parliament as to the representation or the chief minister.
I think it would there would be a process for choosing, but the more logical way is to look at those members of the parliament who come from the same district as the local councils provided here.
Thank you, Mr. Speaker. Let's move to Lapit na. Lapit na yung bukuan. On section 114, there was enumeration of the committees. Maybe it would be helpful that in the IRR, there should be a definition of these committees. Just for the record, Mr. Speaker.
We're okay with that, Mr. Speaker.
Let's move to 116. Yung word na Regional Development Council, I think it should be BEDC already.
Yes, Mr. Speaker.
In due time, we will amend. Section 120. What is the implication of this section with regards to the provision of the administrative code on the Bangsamoro Economic Zone Authority.
Well, Mr. Speaker, under 120, while the power to establish special economic zones pertains to the Parliament, there should be concurrence also by the local government unit covered by the said zone, Mr. Speaker.
So that means to say, it's still the BESA, but it should be concurred by the concerned LGUs.
Yes, Mr. Speaker.
Thank you, Mr. Speaker. On section 121, I think this one is very important as we have so many disputes, boundary disputes within and outside the territory of the Bangsamoro. In subsection F, can we go to letter F? Boundaries disputes involving province in the Bangsamoro Autonomous Regions on one hand and province outside the region on the other hand shall be jointly referred to where?
We have corrected that, Mr. Speaker. So on the right column, in the right column, you will find the proposal, Mr. Speaker.
And it should be?
They will be referred to the higher constituent sanggunian of the local government units concerned.
A province to.
We said any local government unit, Mr. Speaker.
Can we have, for example, a concrete example of what do we exactly mean?
So, Mr. Speaker, between maybe the municipality of Ampatuan and Isulan ba ang katabi niya?
This is a province.
We've changed it to cover any local government unit.
So any local government. But okay. So ano na nga yung example?
So if it's Ampatuan, yun na ba ang last sa Maguindanao? Ang katabi ay Esperanza?
Das, Dato Abdullah Sangki.
Das, and what is the neighboring
Sultan Kudarat.
Esperanza.
Oh.
Then the dispute shall be brought to the Sanggunian Panlalawigan of Maguindanao and Sultan Kudarat, Mr. Speaker.
And they will going to resolve it as to
There will be process where they endeavor to enter into an amicable settlement, Mr. Speaker.
And
So
if not resolved within their level, what are the remedies?
then they can always go to court, Mr. Speaker.
The next step will be
Yes.
in court.
This is
No,
just
no,
for,
no more higher authority that would mediate
yes.
the process.
Yes, Mr. Speaker. Or if there's no settlement that's arrived at, then the parties may go to the court
Court
to
already.
raise their concern.
Thank you, Mr. Speaker. May tinanong kasi sa akin kanina lang sa Lanao daw. Yan ang problema. So, kung kasama ba daw yan sa provision ng local government code. So, nandito na. Yung tanong, sagot sa tanong kanina. Let's move to ay, salamat. 79 of 79 for Book 1. I guess I stop here for Book 1. I'll give the floor to other interpellators. But Mr. Speaker, please give me the opportunity to continue as I have still for Book 2, 3, and 4.
Yes, I think the committee has no choice but to allow also the interpellator to take time to refresh and replenish her strength to interpellate. Or leader, any other interpellator?
Uh,
But may I remind the first two interpellators that you have already taken your opportunity to interpellate Book 1. Huh? No more questions on Book 1.
Yes, Mr. Speaker, there were members of the parliament who signified their intention to interpellate. However, they are asking if they could interpellate tomorrow. So that includes tomorrow. Are you ready? Okay, so Alhamdulillah, Mr. Speaker, MP Rasmit Mug is now ready to interpellate. May we recognize MP Mitmug, Mr. Speaker.
The gentleman from Lumba Bayabao Lanal del Sur is recognized.
Mr. Speaker, magandang hapon po. Presiding Officer, Chair of the committee. Mr. Speaker, I would like to propound my questions in relation to the Bangsamoro Local Government Code. Mr. Speaker, I understand that this code has undergone a lot of review. It has undergone a small group, the last review of the committee and the final review of the committee. And I would like some assurance from our committee chair that this one of those standards that they followed is the non-diminution of the privilege already enjoyed by the LGU.
Yes, Mr. Speaker.
Maraming salamat po, Mr. Speaker. Mr. Speaker, sa unang question ko po sa Chapter 1, in relation to Section 6, Local Government Units, napansin ko lang po, Mr. Speaker, ang paggamit po natin dito, authority to create local government units. Initially, dun sa original draft, ang ginamit natin municipality or a barangay. Pero napansin ko din, yung paggamit ng local government unit dito, eventually, may exception yung pag-create ng legislative districts sa level ng Congress. Pero napansin ko after nito, Mr. Speaker, local government units ginamit sa Section 6 at tuloy na ginamit sa ibang section. Pero actually, ang reference lang po niya, Mr. Speaker, is municipality and barangay. Tama po ba to, Mr. Speaker?
Yes, Mr. Speaker. As mentioned by the good member of the Parliament, the first part of Section 6 makes reference to local government unit as a general description of the entity that that may be created, but we made a distinction in the succeeding part where we say that if it's a barangay, it may be created by the Sangguniang Panlalawigan or Sangguniang Panlungsod as well as the Parliament, or if it's tama ba? And if it's a municipality, it's an act of creation coming from the Parliament, Mr. Speaker.
Salamat po, Mr. Speaker. So, napansin ko po, Mr. Speaker, patuloy po yung paggamit kasi ng local government unit. Pero at the end of the day, it's actually just referring to municipality or barangay. Ang problem ko po nito, Mr. Speaker, is pag sinabi mo kung local government unit, minsan pumapasok din po sa isipan natin, probinsya at city. Tama po ba to, Mr. Speaker?
Mr. Speaker, may we be guided by the good MP by pointing out which specific
Mr.
section or which part of the section he is referring to?
Tama po, Mr. Speaker. Section 6 po yung pinag-usapan natin ngayon kung saan sinabi local government unit. Then dahan-dahan po specify municipality created by sangguniang panlalawigan, then later on panglunsod para dun sa sa municipality. Then eventually pagdating po sa province, yung Congress po. Subalit po, Mr. Speaker, yun po yung sinasabi natin. Most of the time, pag sinabi nating local government unit, sa konteksto po nito, is karamihan dito nire-refer po natin is barangay or municipality. So ang tanong ko po, Mr. Speaker, pwede po ba, minsan depende din kasi sa style, pwede po ba kung saan barangay at municipality lang specific, barangay at municipality lang ilagay natin, hindi na natin gamitin local government unit?
Mr. Speaker, if we will read the first paragraph first of section 6, the reference to local government unit is necessary because we're talking about the power of creation, division, merger, and abolition. And then we differentiate. It's either by law, and that is the power of the parliament, in the case of creation of municipalities or barangays. And then it can also be by ordinance, this time passed by the Sangguniang Panlalawigan or Panglungsod in the case of barangays. So there's an effort to make a general statement saying that the power of creation, division, merger, and abolish over local government units is there, but there's a distinction as to how they are created, divided, merged, abolished. And this time we make a differentiation between the barangay and the municipality, Mr. Chair, Mr. Speaker.
Okay, Mr. Speaker, maraming salamat po. At least mas malinaw na po ngayon yung paggamit ng local government unit. Mr. Speaker, ang pangalawang katanungan po ay nasa page 11, naming of PLGUs and public places. Dito po, Mr. Speaker, napansin ko sa 7160 po, Mr. Speaker, ang naming of local government units and public places ay powers po ng Sangguniang Panlalawigan. Subalit dito po, na-mention pati na din po ng Parliament. Madali ko pong maintindihan na power siya ng Sangguniang Panlalawigan kasi of local interest siya. Ibig sabihin, pag nag-name ka ng place dun sa lugar mo, power siya ng elected officials dun sa lugar. At kung mapansin nyo, Mr. Speaker, sa next na section, kinakailangan yan ng unanimous votes ng local elected. Subalit, nilagyan natin na kasama dyan, pwedeng mag-name kung yung local interest, medyo magiging malabnaw na siya sa regional level. Kasi sa region po, hindi naman lahat nanggagaling sa isang area lang. Iba't iba yung background nila, iba't iba yung interest. At kinakailangan ng unanimous vote. So sa tingin ko, Mr. Speaker, baka mas maigi yung dati, yung kwan lang po siya, Sangguniang Panlalawigan. Pero nais ko din po malaman bakit nilagay natin yung Bangsamoro Parliament.
I think,
Section 13 po siya, ma'am.
yes. I think this also falls under the general power provided under the Bangsamoro Organic Law to over the matter of maybe under the in the BOL under in the enumeration of powers, Article 7 over history and culture And this may include naming of local government units in accordance with history of the Bangsamoro, Mr. Speaker.
Tama po yun, Mr. Speaker, nasa BOL po yun. Pero itong local government code po kasi, ito po yung pagbigay natin ng devolution o ng power sa LGU natin. Gusto po natin sa puntong ito, certain powers na meron naman tayo, pero sa tingin natin mas nakakabuti para sa local government units, ibinibigay po natin sa kanila. At that point, Mr. Speaker, I would like to reserve my right to introduce amendments, Mr. Speaker.
Yes, Mr. Speaker, I think it's a shared power, but if the good MP wants to propose amendments, he may do so during the period of amendments.
Mr. Speaker, ang next po is yung sa page 13 and 14.
May I interrupt for a while?
Yes, Mr. Speaker.
How about if because I read in this provision as a provision in the BOL that that the Parliament cannot, I mean, in the naming of the streets, names of persons or families are no longer are being discouraged. So that when a certain road in a certain province is named after a certain person, the Parliament can change it, right?
Yes, Mr. Speaker, there's also a prohibition on naming these places, institutions, or buildings or LGUs after a living person. That is correct.
Thank you.
Mr. Speaker, however, there's also a safeguard on this. With this new Bangsamoro local government code, if it passes, hindi na lang po siguro basta-basta makapagpangalan sa tao. Kasi po, kailangan nilang dumaan sa BCPCH. So may safeguard po tayo. So ang interest natin with the devolution, since this is a devolution document, we also empower our partners, Mr. Speaker. Next, Mr. Speaker, is yung sa page 13 and 14, Bangsamoro Holiday Law. I've noticed na meron, ito din po yung bill, yung batas natin, Mr. Speaker, reflected dito in relation sa holidays.
Yes, Mr. Speaker, but also with the consultation with the Bangsamoro Commission for the Preservation of Cultural Heritage, Mr. Speaker.
Thank you. Mr. Speaker, in relation to, ang next po is sa page 15. In relation dito sa powers, kasi ito, basic serve, dati, sa dating batas, dating draft bill po, Sir Speaker, basic services and facilities, then eventually naging basic services and facilities devolve powers, functions, and services. Medyo nakakagulat lang, Mr. Speaker, kasi sa section 17 meron enumerations from A to, actually lumampas pa ng X, lumampas ng X at madaming delete. I would like to be ensured, Mr. Speaker, na pursuant dito sa section 405, 469, 495, and 511 of Book 3, lahat ng powers na to ay still protected and andyan po, Mr. Speaker.
Well, Mr. Speaker, first I'd like to explain that I think there was an error in the amended version on the right, in the right column. There should be a strike through for the words basic services and facilities so that it will read section 18, devolve powers, functions, services, and facilities. So originally, Mr. Speaker, under the bill and patterned after RA 7160, there's a list of all these services and facilities. But since, as mentioned earlier, this is Book 1, this is general provisions, and there's an enumeration also of certain powers under city, municipality, province, and barangay. Our proposal is to move the enumerated items to the other appropriate sections, Mr. Speaker. They may be worded differently, but generally they cover the same matter and maybe even more, Mr. Speaker.
Maraming salamat po dun, Mr. Speaker, dahil hindi siya nabawasan, nadagdagan po yung devolved powers and responsibilities. So, Mr. Speaker, may isang interesting portion po dito sa devolved powers, no? Ito yung letter E. Letter E. Ito yung related sa when comprehensive review assessment heard about, kasi kanina narinig ko po
What
yung transition
page,
committee.
Mr. Speaker, so that I can read the provision.
Ito po, page 19 po siya, Mr. Speaker, letter E. Ngayon B na po siya.
Okay.
Narinig ko po kasi kanina, Mr. Speaker, na magkakaroon ng devolution, may 5 years po tayo. At interesting po na mention yung transition committee. So ibig sabihin po ba, Mr. Speaker, this is currently ongoing na yung transition committee? Kasi actually ang tanong ko dito, kailan magsisimula yung comprehensive review and assessment? Kasi kanina may narinig na akong transition committee.
Mr. Speaker, it's devolution committee. This has
Devolution
not been constituted. It will be constituted upon enactment of the law, Mr. Speaker.
Mr. Speaker, hindi po natin nakita sa letter B yung tinatawag na nating devolution committee. Is it but proper na mag-reflect yung pangalan ng committee dito, Mr. Speaker? Para alam natin sinong responsible.
Mr. Speaker, it's in Book 4 because it's just transition. So we put all the transitory provisions to Book 4.
Okay, so salamat po, Mr. Speaker. Then, Mr. Speaker, dito sa dating letter H, ngayon letter C na, ito yung tinatawag na shares from the national taxes. Ito po ba yung natatanggap ng mga barangay ngayon, Mr. Speaker? Munisipyo at probinsya?
No, letters. I think, Mr. Speaker, under paragraph C, if I'm looking at the specific provision being referred to, which is on page 20, this talks about the giving priority to funding all the devolved powers, Mr. Speaker. So we're just saying that in appropriating the funds, the local government, the funds that are available to them through their appropriations ordinance, they should look at the list of devolved powers and functions and prioritize funding all the PABs under these devolved functions.
Pero ito po
Mr.
yung, Mr. Speaker, ito po yung natatanggap ng barangay, province, pati ng LGUs
Yes.
ngayon.
So these are shares in national taxes. These may also include revenues from their share in the revenues from the exploration, development, and utilization of natural resources. It may come from their own local enterprises. So all the funds that are available for appropriation, Mr. Speaker.
Ang pagkaintindi ko po, Mr. Speaker, sa proseso natin ng devolution, katulad ng nasabi din po ng butihing chairperson natin is mas madami pa tayong nabigay na devolved powers to the LGU. Would it also be on our best interest na we assure them na matatanggap nila yung pondo? Kasi currently, yan yung naririnig natin sa mga barangay, munisipyo. Mukhang hindi po nila natatanggap. Baka interest din po na ba natin na parang IRA na kailangan matanggap nila yun para yung devolved powers magawa nila, Mr. Speaker.
Mr. Speaker, can we be more specific and which funds we are talking
Yung
about?
sa barangay funds po, Mr. Speaker, kasama natin si MP Ras Ismael. Minsan sinasabi niya yung problem dun sa barangay nila, hindi na-release yung national funds.
Okay, maybe, Mr. Speaker, the idea here is for all LGUs to receive the funds.
So would it also be our best interest na assured ito? Ibig sabihin may assurance like the IRA to be released to the barangays and the LGUs and the national and the provincial government.
I think we do not have any control over the release of MTA. This goes directly to the local government unit and does not pass the Bangsamoro government, Mr. Speaker.
So hindi po to, Mr. Speaker, yung local funds na sinasabi.
Local funds would be the share from other funds, not national tax allotment. So yung national tax allotment po, diretso sa LGU. Meron din po silang share coming from, kunyari, national taxes collected within the region where there is a sharing between Bangsamoro government and the different local government units. And prospectively, when there's exploration, development, and utilization of natural resources, and there are revenues therefrom, there shall also be sharing between and among the LGUs as well as with the Bangsamoro government.
So,
Mr. Speaker.
Mr. Speaker, hindi po ba itong fund na to ang nagre-release is yung treasury natin? Sino yung punong abala sa level?
So there are steps, Mr. Speaker. There is a computation that should come from the BIR, which is submitted to the Ministry of Finance through the Bureau of Treasury. And on that basis, there will be computation as to the sharing that will be implemented, and the funds based on the formula shall be given to the LGUs, Mr. Speaker.
Siguro meron po ba tong provision sa later book, Mr. Speaker, para mas mapag-usapan ng mahaba? Kasi ang pagkaintindi ko, Mr. Speaker, ang pinakatanong talaga is, pag may ganitong pondo, sino nagre-release para assure yung local government unit natin, para assure yung mga dinevolve nating function, magampanan po, Mr. Speaker.
Well, Mr. Speaker, we can listen to proposals coming from the good MP if that is the proposal, Mr. Speaker.
Yeah, another clarification. Once the share is being released, is there a conduit agency that receives it? Let's say for the barangay, does the share pass through the city government or directly to the barangay LGU?
Mr. Speaker, it goes directly to the LGU concerned.
Thank you.
We serve our right, Mr. Speaker, to ideally at least propose some amendments, Mr. Speaker. Mr. Speaker, sa page 21 po, section 19, maganda po narinig natin, full devolution ang Marawi City, Cotabato City, and Province of Basilan. Subalit, Mr. Speaker, medyo na-notice ko, meron pa tayong pahabol na without prejudice, pwede pa tayo maglagay doon. Ang pagkaintindi ko po ng devolution, once we provide them the devolved authority, no? Ang sa atin na lang is yung assistance. Kaya with section 19 is section 20, augmentation rule. Ibig sabihin, yung next, for example, kung city siya, ang next sa kanya is tayo, the region. Pwede tayo magbigay ng tulong. Pero first po, Mr. Speaker, with full devolution, medyo gusto ko lang sana ng clarification. Bakit without prejudice pa tayo? Parang may pahabol pa na ibibigay namin sa inyo, pero oops, pwede pa din kami. So medyo perplexing, Mr. Speaker. Bakit nilang natin ibigay yung full devolution para sa mga LGU na to?
Well, I think, Mr. Speaker, the full devolution is there. But as I said, there will be transition. There is going to be an assessment of capacities and financial and technical. I will give an example, Mr. Speaker, in relation to the Ministry of Social Services and Development. So sa ngayon po, nagbibigay tayo ng parang financial assistance to vulnerable sectors. And while we give this through our provincial and municipal social welfare officers to the different municipalities in the Bangsamoro, there is a different setup in Cotabato City, Marawi City, and Basilan. So if we read section 19, we will no longer give to vulnerable sectors in Basilan, Marawi, and Cotabato City. But that may mean that we are depriving also the constituents of these local government units that may not be able to receive the same assistance if their local government unit does not provide the same program. So right now, while we engage with these local government units through memoranda of agreements pertaining to these specific programs, we need what we've experienced so far shows that there is a need to have sub-offices in these provinces for better coordination. So, kunyari po, posibleng mag-download sa local government unit, but liquidation, for example, is something that is provided in the Memorandum of Agreement and needs follow-up with the LGU. So it's there's that need, I think, for the ministries to still have that option to set up offices in the said localities when needed, of course, Mr. Speaker.
So Mr. Speaker, para klaro lang po, yung without prejudice na mag-set up yung Bangsamoro government is not really the same as yung augmentation rule ng Section 20.
Pwede rin po. If there is an LGU that will say or based on the assessment is not able to provide the basic services, then that's where the need for sub-offices may come in. And that is still an option for the Bangsamoro government. We do not want to see constituent units in the BARM to be deprived of the same programs and services that we offer or that we provide to other LGUs, Mr. Speaker.
Would it be hurtful, Mr. Speaker, if yung without prejudice rule, since yung augmentation rule ngayon is almost the same with the without prejudice na phrase, can we delete the without prejudice and be focused on the augmentation rule, Mr. Speaker?
I think, Mr. Speaker, I think Section 20 talks about augmentation. That means certain powers that are already devolved cannot be fully exercised yet by the LGU. So that's when the higher LGU or even the Bangsamoro government can augment and provide that service which cannot be taken on by the specific LGU. For Section 20, the sub-office may provide the augmentation, but it may also provide certain services that are not devolved to LGUs. So it's not the, strictly speaking, augmentation, but we're saying that even with devolution, there are certain programs that will still be lodged with the regional government, with the ministries. Mag-example uli po ako at ihahalin tulad po natin with DSWD pertaining to local government units. So kunyari po ang programa ng 4P, Sustainable Livelihood Program, Social Pension, these are nationally funded programs. Even if there's devolution under RA 7160 of powers over social welfare to LGUs, These programs are still lodged with the DSWD, and they have field offices. These field offices now work with LGUs so that the same program that's available to the whole country can be implemented in that specific LGU. So it's not augmentation in the sense of looking at the programs or powers that are devolved but cannot be exercised yet, but it's also additional programs that will be retained by the higher LGU or by the Bangsamoro government, Mr. Speaker.
Maraming salamat mo, Mr. Speaker. Mas malinaw na katulad pala to nung yung mga programs na receive natin sa DSWD at ibang national offices at potentially katulad ng mga PMOs na gagawin dito sa areas natin. Mr. Speaker, in relation sa Section 20, para lang mas maging klaro, kwan po ba to hierarchical? Kasi doon sa DRRM law natin, meron siyang stages. Kung affected yung ilang municipality sa kapapasok yung isa, dito ba sa augmentation natin, kunyari municipality, pwede bang diretso si BARM region, hindi na kailangan dapat nandyan muna si provincial government, hindi muna nandyan si municipality kung si barangay ang concern. So ibig sabihin from the region, direct kay barangay, direct kay municipality. Yun po ba yung sa augmentation natin or katulad sa DRRM na may stages?
Well, Mr. Speaker, I think it depends also on the situation where a certain level of local government is not able to provide the service. And for example, even in calamities, while the next hire would be expected to provide the assistance or the service, even those that are higher than the next hire can come in and do the augmentation, Mr. Speaker.
Maraming salamat po, Mr. Speaker. Ibig sabihin, laging handa si Bangsamoro Region para sa province, municipality at barangay. Ang next po, Mr. Speaker, ito po yung isa sa mga tingin ko pinaka-importante na portion sa code. Itong section 28, which is sa page 27, kasi legislation. Pagkaintindi ko po dito, yung BLGC, itong Bangsamoro Local Government Code natin, is the main form of regulation na sinasabi sa BOL para sa ating local government units at sasabihin niya ano yung powers ng Chief Minister, ng Minister, at paano yung mga taxes. Naintindihan ko naman po yun, Mr. Speaker. Pero gusto ko lang malaman in relation sa after ng BLGC natin, yung mga later laws ng Parliament, would those still be considered legislation of regulation, Mr. Speaker?
Mr. Speaker, if these are laws if these laws that are enacted subsequent to this code pertain to local government units, then that's also part of regulating the affairs of LGUs, Mr. Speaker.
Maraming salamat po, Mr. Speaker. Ito naman po sa Section 29, Mr. Speaker, regional supervision. Naintindihan po natin na yung ating Chief Minister ay may general supervision sa province and through the province sa municipalities. And yun po yung level ng general supervision. Subalit, sabi sa BOL, yung kabinete ang executive power. How do we reconcile this setup na to, Mr. Speaker?
Yes, Mr. Speaker, I think it's when we say the Chief Minister, we're talking about the Chief Minister also as the head of the cabinet. And he may direct the other ministries that form the cabinet and other agencies when there's a need for intervention from these agencies and ministries.
So, can this general supervision be delegated, Mr. Speaker? Kasi yung sa presidente natin, at a certain point in time, it was delegated to the DILG. Can this power be delegated, Mr. Speaker?
I think, Mr. Speaker, that can be an arrangement under the setup, Mr. Speaker, but we've made sure that in the Bangsamoro Local Governance Code, it is clear that it is the power of the Chief Minister.
Thank you,
Mr.
Ms.
Speaker.
Salamat po, Mr. Speaker. Ngayon po, Mr. Speaker, sa page 29, section 30 po, coordination and participation between the BARM and consistent LGU. Nakalagay po dito is kung may mga national policy standards concerning LGUs, papasok po to sa IGR. Naintindihan ko po yun, Mr. Speaker. Subalit, yung reverse po nun is medyo gusto ko maintindihan ng mabuti. For example, at a certain law already passed, merong rights or merong at least benefits yung isang local government unit, barangay, municipality, province, city, sa batas na yun. Dadaan pa po ba sila sa IGR to access those incentives? Ang example po dito, Mr. Speaker, is sa library. Sa library po, nagbibigay po yung National Library with DILG na mga books dun sa ating mga barangay, sa ating mga libraries sa LGU level. Tapos sa Creative Industry Act naman, Mr. Speaker, yung cities natin, basta meron silang council, they can access some resources sa national government in relation dito. So, yun po yung nais kong maintindihan, Mr. Speaker. Would this be barring the local government units, barangay, province, city, municipality, from accessing benefits from national laws?
Mr. Speaker, I think the idea in the arrangements between Bangsamoro government and the national government in the context of autonomy is that, well, first, all the powers that have been devolved to the Bangsamoro under the BOL should be recognized and respected by the two parties. And therefore, we need the intergovernmental relations mechanisms so that any concerns in the exercise of powers by one or the other can be threshed out. And also, Mr. Speaker, for coordination. So even if it's a power that's within the national government and not with the Bangsamoro government, it would still be good to have coordination so that the Bangsamoro government would know all these programs and projects that are implemented within its area of responsibility, considering that it has it is also the area of responsibility of the Bangsamoro government, and so there will be no duplication of the same programs, projects, if the Bangsamoro later decides to have these programs and projects, Mr. Speaker.
So currently, Mr. Speaker, for example, yung na-mention natin kanina, yung sa books sa libraries, yung sa creative industries na may fund for cities with with art councils, no? Kailangan nilang mag-register sa IGR para maka-access sa funds and resources na pinamimigay ng national government.
I think that would be the most ideal situation, Mr. Speaker, since the matter of education, the matter of local governments ba yun? The other example are within the powers of the Bangsamoro Autonomous Region, Mr. Speaker.
Mr. Speaker, medyo concerned lang ako dun kasi would there be penalties, for example, if a local government unit accepted resources from the national government kasi may batas naman na hindi na pag-usapan sa IGR? Would there be consequences?
At present, I don't see that in section 30 and other provisions of the Bangsamoro Local Governance Code Bill, Mr. Speaker, but I think there should be clearer guidelines being known or being presented also to the local government unit so that while we take advantage of programs and projects coming from national government, we are still coordinated and we do not do harm to the concept of autonomy in the that was hard fought and is already within the powers of the autonomous region, Mr. Speaker.
Since clearer na po yung topic, Mr. Speaker, na ideally yung local governments unit natin, hindi sila hingi sa national. At kung hingi sila sa national, dadaan sila sa IGR. How about congressional funds, Mr. Speaker?
Coordination.
Lalo, ako, wala akong problem. I think it will apply to congressmen outside the BARM. Pero meron po tayong mga congressmen inside the BARM who assist our LGUs. Would this be a bar? Ito ba ay kailangan pag-usapan sa IGR?
Well, I think ideally, as I said, for coordination, particularly for programs related to powers that have already been devolved or transferred to the BARM, it would be ideal to have a mechanism by which Bangsamoro government and the specific ministries would know about these programs and projects. Again, so that we do not duplicate, and also we are able to respond to queries from other constituents who may be asking why this certain program is being implemented in a certain municipality or barangay and not to other areas. So coordination would still be something that we want to see in this on this matter, Mr. Speaker.
Maraming salamat po dun sa magic word na coordination, Mr. Speaker. Pero kung yung LGU nais niyang magtanggap ng pondo na galing sa national, alam naman natin na bawat ministries natin may parang counterpart sa national, but they're not actually one unit. So dito ba ang LGU magpapaalam sa MILG o magpapaalam sa, for example, kung education kay MBHTE? Para maging klaro po kung paano yung level of coordination, Mr. Speaker. At kung hindi siya nasasaklaw sa ibang provisions, baka pwede tayo maging klaro dito sa provision na to, Mr. Speaker.
At present, Mr. Speaker, I don't see a very specific provision pertaining to that situation. And if the good MP would like to introduce that in the period of amendments, we will gladly consider the suggestion, Mr. Speaker.
Mr. Speaker, maraming salamat po dun sa sagot. Ang next po is dun sa letter V, LGU participation. Naka-mention po dito is LGU participation doon sa programming, Mr. Speaker. Ang question ko po, ano po yung mga succeeding provisions? Kasi hindi natin nilagay specific. Ito yung mga succeeding provisions na the LGU can participate in... Ang letter B po pala, Mr. Speaker, is yung sa sub-regional offices. Ang tanong ko po pala dito is, ito po ba yung sub-region na sinasabi sa BOL?
Not necessarily, Mr. Speaker. I think it can be in the level of a cluster of municipalities or a cluster of provinces, or for each province, I suppose that's also a possibility.
So, Mr. Speaker, klaro lang, hindi ito yung tinatawag nating sub-region ngayon.
Not necessarily, Mr. Speaker.
Copy po, Mr. Speaker. Yung sa second pala, kaya nalilito ako kanina, etong sa letter C, sinasabi dito, the local government unit shall be involved sa planning stage and process of implementation. Pero hindi natin, unlike sa other provisions, nilist ano yung yung mga future provisions that will implement this. Can we have an example, ano yung unit na importante dito?
Not exactly sure, Mr. Speaker, what the question is, a particular unit, particular LGU unit.
Particular provision in our code, Mr. Speaker. What particular provisions in our code that will ensure that there will be, kasi pwede nating sabihin that there shall be coordinated planning and process of implementation, may coordination. Pero what specific, saan natin makikita yung ganitong klaseng dynamics between the LGU and the region in relation to this sa letter C po, Mr. Speaker. Kasi ang nakikita ko pwedeng sa local development council, pero gusto ko lang makasure na aside from the local development council, may iba pang mga provisions na upholding this idea, Mr. Speaker.
I remember, Mr. Speaker, that there was a specific provision discussed or raised by MP Ampatuan pertaining to involvement of LGUs in or being consulted with respect to programs and projects that will be implemented in their areas of responsibility, Mr. Speaker.
Salamat po, Mr. Speaker. The LGUs, then gusto lang natin makita. Pag sinabi ang LGU ay may coordination with the region, kaya po natin i-enumerate ano yung mga provisions ng ating code or ating batas para doon. Next po, Mr. Speaker, sa letter D. Yung letter D po, Mr. Speaker, sinasabi na pagka may sulat sa Ministry of Interior Local Government Unit, pwede mag-utos ang ating Chief Minister na mapagbigyan ng financial assistance and other form of assistance yung LGU unit. Ang pinagtataka ko lang, Mr. Speaker, is this only true for the MILG? Kasi ang local government code po natin is not only concerned with MILG, it's also concerned with education, health. Kaya yung tanong ko kanina, would these LGUs, all LGUs, maski na ang issue is health, education, labor, sa MILG ba nila i-course through yung kanilang letter to the Chief Minister?
Mr. Speaker, I think the paragraph D contemplates of a situation where provincial offices may no longer be there, so that the different ministries that used to have provincial offices will no longer be directly connected to the LGU. And this is LG, which will still operation will have information as to the needs of the local government unit. But so we're just centralizing the communication, the request for financial, technical, and other forms of assistance. But the different ministries may be directed by the by the Chief Minister, depending on the specific need of the LGU, Mr. Speaker.
Can the request be also forced through the Parliament, Mr. Speaker, through a resolution or a letter from a member of Parliament?
I think that is not precluded by this provision, Mr. Speaker. It just means that even when we devolve the MILG as a maybe we can say that the direct information may come from them, also has that responsibility of transmitting requests for assistance from the different ministries of the BARM, Mr. Speaker.
Pero if it's the Parliament, Mr. Speaker, hindi na tayo mag-course through sa MILG, we just send to the Chief Minister.
No need, Mr. Speaker.
Maybe
yes.
Sir Speaker, I would like to reserve my right for potential amendments in this provision, Mr. Speaker. Mr. Speaker, in relation to page 30 po, section 32, Na-mention po kasi dito government authorities.
Sorry, Mr. Speaker, I failed to listen.
Sa section 32 po, Mr. Speaker.
Okay.
It's the same page. Napansin ko lang po kasi kanina, di ba, ninote ko yung local government unit. But this time, ninonote ko is government authorities. When we mention government authorities, does this mean very specific regional government authority or national government authority, Mr. Speaker?
Authorities are also covered, but considering the limited powers of the Bangsamoro government, it is more on the Bangsamoro ministries, offices, and agencies that will have to ensure that there is speaker.
So, Mr. Speaker, it means dito sa section 32 that this is Bangsamoro Government Authority.
Well, I think we want to cover all, including national government, except that national government may say that our law will not cover them. So we are left with the Bangsamoro government, Mr. Speaker. But the concept of consultation, I think, is covered by other national laws.
O'clock. May I ask the interpellator is if your lineup of questions is already not yet in the middle. I think we will need to continue tomorrow. We already reached our allotted time of 5 o'clock today. We started early at 8:30, 9 o'clock. So we will resume tomorrow at 8:30. I think it's important that both the interpellators and the members of the committee are present and the secretariat are present as early as 8:30 so that we can proceed. Start early, and important that the floor leaders also here already at 8:30 so that we can start immediately.
I was here at 8 a.m. earlier, Mr. Speaker. Mr. Speaker, so just for the guidance of all members who wish to interpellate tomorrow, so we will start with MP Mitmog in the morning, and then MP Alamia, Mr. Speaker. Afterwards, the others who
I
would
think
like
MP Mastura and MP Sema Ron.
Okay. Mitmog, MP Ramos, and then MP Alamia.
Yes.
Thank you, Mr. Speaker.
Madam Floor
Session
Leader.
is suspended until